Dharwad benchmark. This number one, order is number one. RH90.
In this matter, there is a direction for the department to produce the inspection report.
Oh, what is it?
I have not received the document report also.
Why? Why is you not when
Very same day.
No. Is this order communicated?
Yes, please.
When did you communicate?
Very same day I have communicated.
Yes. This court has passed an order on 26/11/2024.
Very same day only.
Whereby this court had directed the respondents on 3/12/2024, and after inspecting the premises, the report should be placed before this court. And also observe that in case as per report, if the construction is made without any setbacks, appropriate orders will be passed, considering the report before this court. The learned government advocate submits that on the same day he has communicated this order to the respondents. In spite of a specific order by this court, the respondent has failed to place the report, and they have not even instructed the counsel appearing on behalf of them. The second respondent shall appear before this court on day after tomorrow, on Monday, along with the report, and explain to the court what was the reason. The direction is given to whom?
To the PWD.
No. Who has to supervise that? Which respondent? Give that order. No respect to the court orders, nothing.
No, very same day I have communicated.
Not about you. I'm listening to your client.
Assistant Commissioner Parati.
The first respondent
No.
who is the first respondent?
They have not made them as a party.
That is true,
My
but
lord has by the document, my lord has directed the PWD and IWTD.
no. Court has said first respondent to issue necessary
Directions to the department.
Who is first respondent?
Deputy Commissioner.
No. First respondent. That day, both of you said first respondent. First respondent is State of Karnataka Principal Secretary.
Yes.
How is he concerned with all this?
On that day, it was directed to the Deputy Commissioner, second respondent, to communicate.
As per the order is first respondent. That day, I remember, both of you said first respondent. I asked who is the authority. The second respondent, Deputy Commissioner, shall place the report before this court as per the order dated 26/11/2024 by 18th of December, or else the second respondent shall appear. And please make them understand that there is a order, or else. Mechanical, I don't want to see their faces.
No, very same day I have communicated by stating all these words. My lord was what was.
No. At least now you tell your deputy commissioner, if report is there, he doesn't have to give it. He has so many other works to do.
Yes.
So tell him that. I don't want to see them morning to evening in the court.
Please.
Yes. Inter-alia granted is extended till then. Yes, next.
Since the 10 days onwards, the respondent counsel has filed assets and liabilities. As per the instructions units, there are some other properties purchased by the respondent husband.
Then counts for the petitioner, it takes time. No representation for the respondents. This is matter on, give some date, 12th of January. Yes. Inter-alia granted is extended. 30. Inter-alia granted is extended. Yes. There is that 2025, the calendar. 25. What dates were from your singing? What do you call it? Around 9? Oh, sorry. Okay. Yes.
Number 3, game part.
Huh? Please use the mic.
Notice issued to respondent 1 to 9.
Not interested. List, provide service of notice, list after service. Yes, thanks.
Number 4, Prashant.
The postal share are not tracking postals.
Post
Item
at-
mode and address absent.
Post at service of notar. Yes, next.
This one. Seal number 5. C. Shatter. Vishwanath Hegde.
Hello, kindly re-sign.
Why?
My lord, we have filed the appeal on 6th May.
As a request, let this matter on Friday.
Arrears have been paid, members, as per the.
Let's this matter on Friday. Yes. Not this Friday. Next Friday.
20th.
Yes, next.
Seal number 6. J. Shetty.
6 Malada, very fine. Remains with petition. Malad, there is relationship has been disputed. Landlord and what the.
What is the office objection? Let's see.
Office of this Malad. It is only Malad.
Here a legible copy of Annexure A, page number 13 to 15. What is your submission?
Malad, it is legible. Page number 37 to 51. Copy.
Even on that also,
Malad.
I've sent them a legal issue your submission is. 30?
37 to 44. Like some urgency was there, that's why Malad it was moved. What happened, Malad, in this case, Malad, the petitioner hearing, Malad, is with denied. Malad, they allege that.
You need to file a
Malad, I will
copy.
file, Malad.
Yes.
But before that, some urgency is there.
Yes, what is it?
Urgency is, Malad, the relationship of landlord and tenancy, Malad, has been disputed by the petitioner hearing. Malad, the eviction suit has been filed. And in that case, Malad,
You are the tenant.
and Malad, it is stated that I am the tenant. It has been disputed by the petitioner. And Malad, what they are saying that they have Malad claiming the property based on the sale. Malad, in respect of that sale,
Registered sale.
Registered sale, Malad. In fact, the contention of this present petitioner is that Malad, that property which is now in occupation of this petitioner is not the subject matter of Malad, that sale. And as such, Malad, it was subjected, and Malad, the evidence is also been given. And after the evidence completed, Malad, an application under Order 26/9 has been filed by the petitioner, stating that Malad, to verify, to commission is required to be appointed to verify whether Malad it is covered under that sale deed or not. So, in order to Malad, the effectual disposal of this. But Malad, that application was came to be rejected by the court below, and Malad, it has been confirmed by the district court also.
Let's see the order.
Order 26/9, Malad.
Let's see the order, impugned order.
Impugned order is Malad, it is Annexure A, page number 16. Reason is Malad at page number 17. And in fact, Malad, the petition by page number 17.
Where is your IA?
Malad, I is Malad, page number 51, Malad, Annexure B. 51.
All the papers which you have filed shows
Right.
how old this case is.
It is
54.
No, 2013. 51.
2013.
In fact,
And
Malad,
it
once
has,
Malad,
it
the
has
order
not
was
even,
passed, Malad, it has
no,
been-
it has not even crossed the stage of the HRC till now.
No, HRC case only. Malad, in fact, in HRC case, if the suppose Malad, there is a dispute is there, it has to be referred to the civil court, Malad, that is
Let's see that please read your,
Page number 51, Malad, is the appointment of court commissioner.
they should have asked you, let us see, 57?
52 is Malad, the affidavit in support
Let's
of.
read the affidavit.
Yes. I am the respondent number 2 for the second paragraph. In this case, I have admitted that Srimati Deepa Arun Pauskar introduced me in the petition premises, and she is the landlady of the petition premises. Hence, I have examined her, our witness, and she sold the petition premises is not sold to the petitioner, and she has disputes the alleged sale deed. She is in possession of the petition premises and building. She resides that in the petition premises building. Hence, it is necessary to measure and find out the truth that in the ground floor, 500 square feet as per the purported have been executed in the sale deed. The petition premises come under the ground floor, 500 square feet, by appointing the assistant executive engineer PW Dharwad as court commissioner to measure and carve out 500 square feet in a ground floor premises portion as per the alleged sale deed to meet the ends of the.
I've seen it. Please come to page 29.
20.
Let's read point number 1.
Yes, 29. Malad is the order passed by the district court. Point number 1.
Yes.
I have gone through the records, the petition.
This is the impugned order, is it not?
No, that is also Malad. Annexure A is the earlier order passed in HRC.
No, I'm looking at the present impugned order.
Both are. Malad.
That is true, that has culminated.
It is confirmed by the district.
So that is the order, the latest.
Yes. Latest is Malad district.
Yes, please read.
I have gone through the record. The petitioner who is the respondent agent has filed the petition before trial court under section 27 to A and to O, to Q and R of the Karnataka Renter, seeking an order of eviction of the respondent agent. The case of the petitioner that he is the absolute owner of the petition scheduled premises, and he has purchased the same from his erstwhile owner, Srimati Deepa, wife of Arun Foster, under the registered sale deed dated 16/5/2008. Before executing the said sale, the erstwhile owner has executed a registered sale agreement dated 17/3/2007. Point for the extension of time of agreement dated 17/3/2007, and he has executed another agreement dated 7/1/2008 towards the same transaction. The erstwhile owner has brought the said back to the knowledge of the respondent that she has sold the said two property to the petitioner. Thereafter, the respondent has agreed to vacate the petition premises and hand over the possession of the premises to the petitioner. That is the allegation made by them. After the said sale, the respondent has agreed to pay monthly rental to the petitioner, and they have agreed to vacate the two premises within 6 months from the date of execution of the sale. The respondents were under the tenants of the erstwhile owner of the premises petitioner on the monthly rental of rupees 1,200, and after purchase of the petition scheduled property, the tenants have agreed to pay monthly rental from 15/4/2018 towards at the rate of 1,200 per month to the petitioner. After the end of every tenancy month, which starts from 15/4/2008 and ends on 14th day of each commencing calendar month. However, the respondents have not paid the monthly rent from 15/4/2008 up to 14/7/2008, which totally amounting to 18,000 as areas of rent. Malad, in fact, there is no rate, Malad, so far as because there is a dispute, there is no question of payment of Malad rent. When the petitioner has requested the respondent to pay the areas of rent, the respondent has agreed to pay the same within 1 month and requested to execute an agreement, and according to petitioner and respondent have entered into an agreement on 11/7/2009 for a period of 2 years. However, the respondent has not paid the arrears of rent amounting to 58,000, and they are due to pay and so on so. Totally, they are liable to pay 60,000, but they have not paid such amount. Hence, the petitioners issued legal notice terminating the tenancy from 10/6/2012, and the said notice was duly served upon the respondent. And in point of the service of the notice, neither they have paid the arrears of rent nor vacated the petition premises. Hence, the petitioner has filed the petition seeking for eviction of the respondent from the scheduled premises. All that is colored back. Then once order was passed, then thereafter the revision was filed. They have filed the petition against.
And you suddenly realized it now. After all this process, you suddenly realized that an application under order 26
No, it is in fact, so far as the appointment of the court commission is concerned, it cannot be before after full completion of the evidence. After completion of the evidence, as there is some gray area wherein the dispute is right. In fact, sale deed, my owner has also objected that he has not sold.
When having executed a sale deed, which is a registered document, just like that your vendor denying it will
No,
not help
my
you.
lord, that's why, what I am saying that this portion of the property, my lord, is not the subject matter of the sale deed.
That
That is
the sale deed
exactly
will
the-
show, that the sale deed will show, why should there be an
Yes, my
inspection?
lord, that we have narrated, my lord, it has been, evidence also been given.
The document
But
is
to,
a
my lord,
self-explain.
clarify the position. Appointment of the court commissioner is required. Otherwise, my lord, it may, my lord, your lordship can see. This point, what we are saying that this portion is not being sold. This petition
For
premises
that
is
it
not
requires a
being.
court commissioner, why?
My lord, sale deed has been produced. And,
Yes.
my lord, sale deed also.
That is sufficient.
No, my
For
lord.
that, why the physical examination is
Sale,
required?
my lord, sale deed also, my lord, refers to, my lord, in fact, that.
But then you rely on that.
The trial court, my lord, as well as the first appellate court, the divisional court, my lord, held that, my lord, because there is a sale deed, my lord, and, my lord, I cannot.
Then how do you
Without,
change
my lord,
it?
verifying,
How do
without
you change
verifying.
it when there is a registered document saying
No.
that there is a sale deed?
Registered sale deed is there, my lord, we are not, my lord, not disputing.
You cannot dispute
We
also because
cannot
you are not the
dispute. That
executor.
is, my lord, it is not. We are saying that, as well as my vendor, my owner is also saying.
Your vendor, just like that in the proceedings of this nature, cannot say
No,
that
no.
I have not executed
No,
the sale deed.
no. In fact, that is the malad where the malad dispute arises. In fact, this portion of the land has never been sold by my landlord also. I continue
That
to
your
be the
landlord
same.
cannot afford to say
Malad, I
in these
continue to be
proceedings.
the and that's why malad to measure this malad with reference malad what I am saying that this property is required to be measured in reference to the sale deed only. I am not saying that
Why
malad
it should be
without
measured?
reference to malad sale
Why
deed.
it should be measured?
But measure and to identify. So whether in fact this is also malad the subject matter of the sale. Malad, because
Such an inquiry can't be done, not necessary to be done.
malad, in fact that is the malad crux of the matter. In fact, the entire dispute between the parties is the malad that. But if the sale deed is malad referred to, and wherein malad the measurement has
Your
to be done,
specific
this
case
is
is,
not malad covered.
your specific case is so and so is your landlord. You are paying rent to them and you have filed earlier suit and he is your landlord and this person, the respondent herein has nothing to do with it. Now you have come up with a new story and your landlord saying that no, I have not executed the sale deed. If
No,
it is a case
malad,
of
she is
yourself.
saying that she is also not disputing that she has not executed the sale deed. She is also saying that this portion has not been sold. This
That
portion.
we can understand from the contents of that
Yes,
document.
with
For
the
that,
understanding,
no
the
commission is required.
contents of the sale deed only. But I am saying that it should be with reference to that sale deed
Not
only.
required, not required.
Malad,
Please come.
otherwise, malad, how malad it is? Malad, in fact, if malad, that's why there is a provision in the malad Karnataka Rent Act also. If there is a dispute in respect of malad, the landlord and tenancy, malad, if there is a serious
Let us
dispute,
please show to this court your objections that are filed by were filed before the rent controller saying that they've
Yeah.
already taken a specific stand that so and so property we have purchased by way of a sale deed of the year 2008.
They
What
say-
is your specific contention?
we say that, malad, it's not at all.
Where did
This
you
portion,
say?
malad, that-
Where did you say?
That is the objection.
Not now by way of an IA.
Earlier also.
Show to
Earlier
the
also.
court, show to the court that.
Earlier also.
Yes, let's see.
Earlier also.
Where is the page number?
Page number. Objection, malad, annexed B.
Page number.
Page number 47.
Let's read.
Malad, page number 49 is irrelevant.
Yes. Para 5, you say
Yes,
about the
yes.
who is the owner of the property.
Yes. Malad, it is malad, in the meeting, malad.
Hmm.
The ownership of the petition from Deepa have filed the suit before the Honorable Principal Civil Judge.
No, before that, hence till the disposal of the above suit, the petitioner has no valid title to the petition premises, has entire possession of the plaintiff premises and so and so.
Malad, it's required to be, malad, that's why malad, we have to say that, we have malad, said that, malad, because there is a dispute regarding the landlord and tenancy relationship, malad, it is required to malad, refer to the civil code.
No.
But malad, because the scope malad, under the malad, the HRC Act is very limited. Malad, very limited. That's why we have stated that it should be referred.
We are on a point on your IA under order 26.
Yes.
Not on the other things.
Yes.
As far as order 26 is concerned, now this court will decide whether it is right or not.
Then your lordship may kindly behold that the question regarding maintainability of the petition, it have to be open, to be executed.
That is not the scope of this.
That is exactly what
petition.
has happened. Now district court as well as the reference, the rent control court held that because another two cases the eviction order has been passed, that's why we will also follow. That is not
come up with an appropriate application.
Those portions has been covered under that safety, but not this. There was a serious dispute by me as well as my landlord also. Unless that has been
with your instead of complying with the objection, with your note, your note and your submission for that objection, you have preponed the destiny of this case. Please come. Agreed by the orders passed.
The question regarding
That is not. Please understand. Please understand. Just because you come to the court, let this court pass some order.
Exactly what I am saying is, now the trial court as well as the revision court held that because there is an eviction order in respect of other two cases, it should be followed in this case also. That is not the case. In those cases, there is no dispute as such. Here in this case, there is a dispute regarding
that is a so-called dispute which you are trying to project. But actually it is not there in your pleadings at any point
in
time.
Even in pleadings also
Your specific case is that you are not the tenant of this petitioner, you are tenant of somebody else. Now you come up with this application saying that my landlord has said I have never sold the property, so there is a dispute. That you cannot say.
In the initial stage, at the time of initial filing of my objection itself, that has been stated at page number 5.
That is not your case.
It is stated.
Your case is that there is no landlord and tenant relationship.
In fact, that is only the question. There is no relationship of landlord and tenant.
But that is a different issue. For that, why should this the whole process be?
It is correlated unless this is
I'm not convinced, Mr. Counsel.
Unless this has been decided. It is not possible to decide that.
The present petition is filed, agreed with orders passed in Rent Revision number 2 of 2024, dated 26 October 2024, whereby the court the district court has confirmed the orders passed in IA number 9 in HRC number 1 of 2013. The petitioner before this court as a tenant. Initially, the respondent hearing has filed a case seeking eviction of the petitioner. Thereafter, the said HRC is allowed by order dated 1/2/2019, directing the tenant to vacate the premises within 2 months from the date of the order. Challenging the said order, the tenant had filed revision petition before the revision petition before the district court and after issuance of notice, and the court by order dated 18/7/2022 allowed the petition with costs of ₹5,000 and remanded the matter to the trial court with the direction to dispose of the petition within 6 months. After the remand, the present application is filed under order 9, present IA is filed, that is I number 9, under order 29 rule 9, seeking for appointment of court commissioner to make investigation and submit report. In support of the said IA, it is stated that one Deepa Arun Pavaskar inducted the petitioner hearing in the premises, and she is the landlady of the property, and she is the owner of the property. The tenant has examined the landlord. She disputed the sale deed and she is in possession of the premises and building. She resides in the petition premises building. Hence, it is necessary to measure and find out the truth that in ground floor 500 square feet as purported have been executed sale deed and petition premises comes under the ground floor 500 square feet by appointing the Assistant Executive Engineer PWD Karwad as Code Commissioner to measure and carve out the 500 square feet in the ground floor portion as per the sale deed. And it is the case that the Code Commissioner is appointed, no proceedings would be caused. The landlord had filed his objections. The court, by order dated 3/4/2024 had dismissed the application and the same was carried in retribution number 2 of 2024. The same also came to be dismissed. While dismissing the same, the court observes that the HRC 1 of 2013 is filed seeking eviction on the ground that he has purchased the premises from erstwhile owner Srimati Deepa Pavaskar under registered sale deed dated 16/4/2008, and the erstwhile owner has communicated the said fact to the tenants. Thereafter, the tenants have continued their tenancy under the petitioner. And as a tenant has failed to pay the rent, the petition is filed seeking eviction. Whereas the respondent tenant has failed to cross-examine and proceed with the matter in spite of giving a reasonable opportunity, the court had ordered eviction on 1/2/2019. The court observes that on one, in spite of an order to dispose of the matter within 6 months, the tenant is coming up with one application or the other, dragging the matter for no reason. The court it is observed that it is not a case for encroachment and appointment of commissioner is necessary for measurement of the property. The code commissioner can be appointed for local inspection, or scientific or forensic investigation, expert opinion. In the case on hand, the petition is filed seeking eviction of the tenant, and the parties have already led their evidence and also produced their documents. The respondents, that is a petition herein, have admitted that they are the tenants under the erstwhile owners of Deepa Pavaskar, and it's a case of the petitioner that he has purchased the property. It's a case of the petitioner means the owner. The case of the landlord that he has purchased the property from the erstwhile owner. Court also observes that there are 3 eviction proceedings filed against the tenants, and out of that, in one, HRC number 2 of 2019 has already been disposed of, and possession has already been handed over to the landlord. The sale deed dated 16/4/2008 is marked as an exhibit, and the measurement of the property is clearly mentioned, and the erstwhile owner has not disputed the sale deed. And
already, as well, owner has also disputed.
No, not in your cross-examination. In their count, the execution of the sale deed is not disputed.
Execution is not disputed, but
the problem is, whatever it is, they can't afford to do it without filing a suit, without anything.
suit is pending.
That will take its own its course. And the measurement of the property is clearly mentioned. The tenants have raised objection with regard to the ownership, and the said issue came to be rejected by the trial court. In those circumstances, appointment of a court commissioner is not necessary and accordingly dismiss the petition. Next para. Let counsel appearing for the petitioner, petitioner tenant submits that even the landlord had supported their case, wherein it is stated that she has not executed the sale. According to him, there is a dispute with regard to whether the property that is part of the sale deed is the property which is the subject matter of the case and the eviction case. In those circumstances, appointment of commissioner is very much required. Unless and until the commissioner is appointed and he inspects the premises and submits the report, the court would not be in a position to come to a just and reasonable conclusion. Without considering all these aspects, both the courts have concurrently had dismissed the application filed by the tenant. Then counsel submits that it would cause loss of a lot of prejudice to the tenant. He further submits that the eviction order that is passed in the other connected matters cannot be considered and cannot be a basis for passing any order in these cases, and the court has to independently deal with this eviction case basing on the evidence let in by the parties. He submits that the order passed by the courts is not a well considered one. Anything else?
Any observation, Malad? Would
That's
not
it, that's
affect on
it.
merits.
Having got the then counsel for the petitioner, peruse the entire material on record. The suit is for eviction. According to the landlord, he has purchased the property in the year 2008 from one Deepa Pavaskar by the registered sale dated 16/4/2008. And as the tenant had failed to pay the rent, he has filed the present case seeking eviction. The respondent has filed his objections. In these objections, he has stated that there is no landlord-tenant relationship, and they also admit the fact that they are the tenants of Deepa Pavaskar. It is also an admitted fact there are another 3 cases of pending with respect to the premises. There are 3 cases, the 3 eviction cases are filed, and one of it is already eviction is ordered. This court has perused objections that are filed and also the present IA. It appears that the tenant is taking shelter under basing on the evidence of the landlord that he has not sold the property. There is a document, registered sale deed, in favor of the landlord, which is of the year 2008. If the landlord denies that such an sale deed is executed, its remedy is before the court, before some other forum. And in these proceedings, the court cannot go into all those issues. This court has to look at the application that is filed by the tenant in the light of the objections that are filed to the main petition. Considering the both, this court is of the view that, as rightly pointed out by the district court, only for the purpose of dragging on the proceedings, the present application is filed, and And such an application and such an inquiry by appointing an advocate commissioner is not required to adjudicate the dispute between the parties. Already the entire evidence is before the court, and without such exercise, the court can decide the same. In the considered opinion of this court, both the courts have rightly dismissed the petition. Next paragraph. The trial court shall dispose of the matter. The trial court shall decide the case on the merits of it, and any of the observations made by this court while disposing of this application shall not be construed as an expression of this court.
By the trial court as well as revision court.
Huh?
By the trial court as well as revision court.
What is that?
Trial court as well as revision court also. Otherwise, you
I
have-
said, this is only my expression. I am not concerned about what they have said. Yes, next.
Which one is number 7? Malikarjun clear? Three.
We have 2 days in filing the judgment.
I number one of 2024 is filed to cut down the delay of 2 days in filing. The delay, accordingly, delay is cut down. Yes,
Defendant of 14 revision petition. The suit is one for partition.
we'll have it tomorrow. We'll hear it tomorrow.
Please.
Lord, next week, Lord, meanwhile, Lord, I file Wakala. Lord, I appear for R1.
Suit is being proceeded.
We'll have it on Tuesday.
Please.
This is matter on Tuesday.
Tuesday.
Yes, next.
7.
I number one of 24 is filed to cut down the delay of so. For the reason stated, the delay is cut down. Yes. This is matter for admission on Tuesday. Yes, next.
Still number 8.
Observation on behalf of the petitioner counsel, due to some technical issues not appear to VC. Kindly post in the next week. He will be appearing in the physical.
Wednesday, at the request of the counsel for the petition. Yes, next.
Still number 9.
Towards, I have no objections to item number 1. Parties were present.
Huh?
The suggestions that the lots are directed to parties were present. Parties to be present for court. Both the parties are for court.
What is this matter? It is submitted that there is a likelihood of settlement between the parties. Both the parties should present before this court on 12/12/2024.
There is huge arrears that is pending. Recovery proceedings.
Now, what is this likelihood of settlement?
We made an FIR with the trial court advocate, and they said that any possibility before the court, it can be go through the parties concerned. Now we have I talked to my client. He said that he is ready to settle the matter, and even I have
In
suggested.
what manner?
It was talks of my party before the trial court that he is ready to afford the amount, some amount. He has quoted some 5 lakhs, and court has suggested that it is not
What
a
is there?
reasonable.
No, there.
No, she is.
No, divorce is granted.
No, that is not. There was petition filed by the petitioner. It was dismissed, and it was not went for they are not. Now, the status
So
is.
that's what is this? What is the settlement?
He is ready to get back her
Is he ready to take her back?
How? But she is not ready. Some person, like, I don't know, whatever that is. So
What is your client says?
Only to overcome the maintenance amount and proceedings, these regular petitions are being filed. Earlier, way back in the year 2020.
No, first question is, that's on the merits of the matter that we will deal with. Is your client ready to join him?
No.
Did you get instructions from her?
No, madam, she's not ready, but there is a son who is aged about 7 years. And the maintenance, the alimony amount that is being offered, that will not take care of.
Oh,
both
you
of
want to
them.
completely settle everything with him?
Settle.
If he is,
Yes.
have you come up with a proposal?
Just for a week,
Then that's what, do it.
Please.
You please come out with a proposal. If it is acceptable to them, it is acceptable, or else we'll pass orders on merit.
Please, parties are well before the court. If possible, we sit together with my friend with the consent. We get together, sit together and make some effort to get
Request for 2 weeks time, Lords. Needs to take instructions from the elders. We'll sit together and we'll submit the settlement report.
So that day they'll come back. Why, if she goes
No,
back, no
what
settlement?
has happened here? Before the trial court, made some effort.
She can
That
speak
is not
English.
that.
She can speak English. Hindi? Let them come to the chamber at 2 o'clock.
Please, take.
2 o'clock, chambers.
Chambers.
Yes, next.
Seal number 10.
Yes.
Position number 8.
Huh?
Both I have filed the petitions, husband as well as wife.
There is
I am appealing
171
for
and 238. Yes.
I'm for, I'm the petitioner in 126.
126.
I am appealing.
What
for
is
this.
126 or
100,126.
And that
In
is
that
filed-
you have a delay of 171 and in her petition 238. Both we will connote
Please, please.
in RPFC 100,126. IA 1/24 is filed, connote the delay of 171 days, which is filed by the wife. Then RPFC 100,188 of 2024 is filed by the husband with a delay of 238 days in filing. Considering both the petitions and the reasons that are stated in support of the same, the delay of so and so is condoned, and both IA number 1 of 24 and IA number 2 of 24 are allowed. This is matter for preliminary hearing. Yes, next.
Seal number 11.
Notice. Yes.
For dismissal matter, seal number 12. By Lakshmi Kant Reddy. Disabani. Seal number 12. By Lakshmi Kant Reddy.
This court on 3/3/2023 has granted interim order on the condition that the petitioner shall continue to pay an amount of 7,000 per month to the wife and children together. This matter came up before this court on 24/10/2024. As there is no representation, directed the matter to be listed on 19/11. Again on 19/11 also there is no representation. Hence this matter was directed to be listed today under the caption for dismissal. Today also there is no representation. Hence the matter is dismissed for non-prosecution. Yes, next.
Seal number 13. SS Bhavan.
This is husband's petition.
How much is granted?
My lord, 12,000 is granted.
12,000.
9,000 for wife and 3,000 for son.
And what is your income?
My lord, the wife is working.
No, what is your income?
My lord, I am doing with father.
As per the evidence of before the court.
My lord, maybe around 40,000, my lord, because I had.
No,
loan.
you've given such an expression as if that you're not earning at all.
No.
Uh,
There is an earning, my lord, because he has.
What is the evidence to show that the wife is earning?
What is earning she has applicant?
Let's see that.
My lord, it is shown to page number 20 of the judgment, recent judgment.
Running page or?
Running page 28.
Yes.
The court offers that. This is the answer of the petitioner goes to show that she has the right to be with the respondent, thereby defendant in her claim. This is the possession part, and so far as job is concerned, that page number 23, my lord. Page number 23, paragraph number 30, my lord. In the cross-examination, PW1 has denied the suggestion that even now she is doing garment business. However, in her cross-examination, PW1 has.
So let's take her income into consideration. She is having 7,000. And how much the court had given? 3,000 to the child, 9,000 to the mother. You are earning 40,000. What's the difficulty in paying it?
Because I got a huge liability because since I borrowed loan and invested in capital.
Let's see that.
So, for that reason,
No.
I have to majorly.
You must have filed your statement of assets and liabilities. So what are your liabilities?
My lord will be borrowing from bank. That is the.
How much? There should be for everything. There should be some calculation.
My lord, next time very.
But just issue notice then, no stay. Notice.
Till next date of payment.
Huh?
Till next date of payment.
Notice to respondents. If you want stay, they should be on condition. On condition, because of these facts,
Payment of 50%.
no 50%.
The 50. Because my lord, she's working woman and
Then with 3,000 your child will live.
my lord, she's earning, when I am
Now
investing.
she's earning, no, she's earning 7,000 and you will give 3,000 to the kid.
She is earning more, madam, but deliberately she has,
That has to be decided.
So far as, election B is concerned, madam, it is a lease deed wherein I have took the property on lease to run her business. She is running the garment business. In spite of earning, she is having business as well, madam.
No, you are earning 40,000, court had granted only
That is
12,000.
not excluding the madam, because I am to discharge my land.
If you want stay on 10,000, maximum that. No, or else no stay at all, notice.
Please, madam, for 50%, madam.
No.
Get 8,000, madam. Because I want my mother to look after me.
Then who will look after your children, your son?
Madam, she is capable, she is well qualified, madam.
And you will not do anything.
No, I am taking responsibility.
First of all, considering your salary, granting 3,000 to the child is on the very lower side. And this court would, if the wife files an application, this court would enhance it.
8,000 would be, my lord, for 8,000.
No. Yes, notice to the respondent.
Yeah.
10,000. They said, and counsel for the petition submits that the wife is earning and these aspects are not considered by the court. They shall be stay of all further proceedings on the condition that the petition shall continue to pay 10,000 per month to both the 10,000 per month, and the arrears shall be deposited at 10,000 within a period of 8 weeks from the date of receipt of the copy of the order, or else the stay granted by this court stands vacated without further reference to the court. Delete from the caption for dismissal. Yes, next.
Number 48, shall I ready?
Yes.
There are two petitions. We can pass over.
Pass over. Yes, next.
Okay, pass. Number 50, motion sanction. Yes, sir.
There are two petitions, one is filed by wife and one is husband. Wife was not granted with any maintenance, and husband has come in challenging the maintenance amount which is granted to the children, 3 daughters.
So you have questioned that. You have questioned that part of it, where the wife, the claim is denied.
So, in fact, on last occasion I have argued, and also of the opinion that because the 2 daughters are major now, they cannot claim maintenance. What that's expressed. Regarding that, my lord, I have answered the judgment.
Till they get married.
Please.
Till they get married.
Please.
There is a judgment of the Supreme Court with regard to this on 125 CRPC and filing an application in the Hindu Adoption and Maintenance Act.
It is the same.
So where they decide that instead of relegating the parties to file another application, it can be granted under this.
No, that they say that liberty is granted to the daughters to initiate proceedings under section 20 subsection 3.
Of the, so that liberty you want now.
That's liberty. And another, my contention is that wife was denied for the only, the maintenance was.
No, in fact, I'm telling you, there is one more judgment where the court said instead of relegating the parties before the other court under the Hindu Adoption Maintenance Act, the court under 125 CRPC can grant maintenance even to the daughters who are major and unmarried.
Yes, I shall find that judgment highly.
They are qualified to earn minutes as of now.
No, that's a different aspect.
Yes, ma'am.
That's a
The
different aspect.
person whom they are claiming from is retired minutes. He is only getting 32,000 as of now, and the maintenance quantum is 24,000 minutes.
Anyway, we'll give him an opportunity to look at that. List is smarter next week on Thursday.
Number 60.
It is second matter, as for the petitioner. That is the first matter copy not
It's a 2022 matter.
they connected.
When did you file your wakalat?
First matter connected. No. In the first matter, copy not served on.
No, that's what I'm saying. In the first matter, you appear for the respondent.
No. They didn't serve copy upon.
Sir, 16.1.
CRP, you are the petitioner.
No.
You are the petition in CRP. So, you want the papers in? Now the whole confusion to the court is who is appearing for whom. No, it is so simple to answer. CRP is yours for the petitioners. Who is for the respondent in the CRP? So there is no difficulty to go ahead with the CRP. Then what about you? Where are you in that petition? Huh? You appear for whom in CRP? Correct. That's what I'm asking. In 16.1, you are for the petitioner. So you want papers in CRP? Yes, we'll accommodate you next week. The line comes for the petitioner in CRP number 10092 of 2022 shall serve copy of the revision on the council appearing for the respondent number. No, you are not a party to the CRP. Then why will they serve papers on you? That's what I'm asking here repeatedly. Then we'll go ahead with the matter. Let the mark with the revision. Yes. Yes, madam.
One submission, let them complete arguments in CRP. But I am responding that written petition, that is 16.1.
That we will hear.
And Mr. No.5 is for the petitioner in the same written petition. And we do not know what is the CRP, what they have.
Let's let them argue. Who are appearing in CRP? Please argue. Yes. Yes. Can you please adjust the mic? Yes.
Was respondent number 1, was Srimati Deepa. She is the plaintiff was before the court.
Yes.
Was the petitioners are defendants was 1 and 3 in the suit. Respondent number 2 was is defendant number 2 in the suit.
What is the suit, sir?
Suit is 5 plus for partition and separate possession. Now plus 1 Jade Gavisiddappa is the proposal. During his lifetime, plus he died on 18th.
No, before that, what is the IA?
Plus IA was filed, that's what the background facts are stating, because IA was filed for, plus there was a critical issue with regard to the maintainability of the suit. The court below, in spite of the earlier proceedings, in spite of bringing into the notice of the court below, plus that there is already a partition in the family during the lifetime of the father, which they also don't dispute, and there is a recital in that partition deed saying that some of the properties plus are not partitioned for the reason that the proposal's brother, plus there was a suit between them. That had been compromised amongst themselves. After the compromise, plus the brother files plus seeks for recalling of restoration of the suit and recalling of the compromise. That was challenged. Then that was dismissed. Against which they had filed a miscellaneous perspective before this order report. And thereafter, they have withdrawn the nothing saying that that is not maintainable and they have filed a writ petition.
No. What was when they filed a petition to recall a compromise?
They had filed.
They had filed.
Yes.
What was the order of the court in the writ petition?
Well, that had been discussed. That application.
On the maintainability.
Not on the petition.
Yes.
On the maintainability.
Miscellaneous application came to be dismissed on the ground of maintainability. They filed a miscellaneous appeal, first appeal for this on court.
Then they withdrew the miscellaneous first appeal. With
No, what is the observation of the court while dismissing it?
The compromise decree cannot be challenged under the miscellaneous application.
So now what is now the present law?
Now the present.
It is maintainable, it has to be before the same court.
Same.
In that case, writ petition has to be allowed.
Yes.
That's number one. Then what about the revision?
Yes, revision. Plus, my contention was that in view of the proceedings pending in that miscellaneous petition, because it has culminated in the writ petition before this honorable court. She could not have maintained this suit because there is a specific recital in the document saying that the party shall not seek for partition fee unless the proceedings was initiated by that.
No, this is like this. No, both of them are interconnected.
Yes.
Now, once we are once this court allows that writ petition,
Yes,
then what should follow?
the revision. Now, what happens is this: revision has to be allowed because for this reason,
That already there is a prior partition.
yes, in view of the prior partition, in view of the deciding the prior partition, that you should not seek for partition till it is concluded. That is, earlier proceedings was concluded. No, she could not have maintained this.
On what ground sought for recalling of the compromise decree? In the writ petition, it is. You appear in the writ petition.
In the writ petition, I don't know.
You don't appear. You also don't appear.
Now,
So where is the counsels appearing in the writ petition? Yes. On what ground you sought for the recall of the compromise decree? Next one.
Only two grounds. One, my last one, the schedule was not included. Apparently, it was included in the compromise. And second ground is that my law, wherein the CC, that is the criminal case is pending against me, that is one of the defendant number one in this suit, wherein that coercion agreement claims and also fraud made upon the.
So you wanted to be recalled on the ground of fraud and coercion.
Yes.
Let's see that order.
Yes.
Executed order.
If you know the law of page only, answer A, at page 120.
120.
Please. That's the reason starts at page 132.
130?
2.
Ah.
Then, that's this one to page 14 there was, page 134.
Ah.
Particular note that inside that, petitioner is seeking for setting aside compromise between Malaysia, Karnataka, page 25.
No, you're reading by I is 49. Yes.
Please. Para 14.
Yes, yes.
25 to 2013, it was on the basis of the compromise entered between the plaintiff and the defendant. Wherein the inside petitioner is also a party on the ground that respondent one, who is the 1997 of court, who is the head of the family after the death of the father of the petitioners when he died, without the knowledge of the petitioners and other legal case of the deceased, the said respondent one, disposed the property being survey number 66B, measuring 7 acres 30 cents, situated at Kopakutta village, Rukumudi, Kopi, Ballari, for a valid sale concession of ₹42,000.
So where is that point which you are canvassing now with regard to the fraud?
Fraud was this property not included in the claim.
That's one. You said that some criminal case.
I also produced connection L and M.
No. Is it not? Where is your IA for that? IA file for that miscellaneous application file.
This and also. Connection D levels, 83 to 1.
Page 83.
83 to 1. 83. Next petition. 17 of 13.
In which para you said about that also?
Please. Para 11.
Para 11. Para 11.
Para 2 minutes, sorry. 2, Roman 2. Page 81. After the compromise in the sense, so immediately some of the available information came to the knowledge of the petitioner. The petitioner's brother, Siddhartha, filed the suit for partition notice 7 of 12. On the file of the settlement, she seen as a judge at Bernard, under the false ground.
Yes, you appear for the respondent. You appear for the respondent.
Respondents,
What do you say? Then why this writ petition cannot be allowed?
My humble submission is, I was appearing for respondents 1 and 3 matters, especially respondent number 3 son is suffering from dengue and he is unable to come here. And I seek instructions because connected CRP is also pending as per the submissions. And it may be posted to next week and I will ask my party.
No, actually your party's consent is not required.
No, whether he wants to continue with me or with another council, because same party in CRP and in WP.
No, anyway, in both the matters, the court is going to pass orders now.
There shall not be any conflict of interest amongst them.
This is heard the councils in part. This matter is part heard on Wednesday, Tuesday. Interim order granted earlier is extended till then. Yes, next.
Would like to.
Still number 17 and 18, action, still number 19. One number, just hold on.
What is this mediation report? Huh? Learned counsel with the respondent wife submits his wife is ready for one-time settlement.
Yes.
Who appear for the husband? No. This order is on 2011-2024. I wanted you to get specific instructions. How much is the amount is ready to pay as one-time settlement? Ask him. As one-time settlement, how much is the amount granted by the court?
5,000.
Divorce proceedings are pending.
Solve closed. Ex parte judgment. They have taken ex parte judgment.
That is not questioned. The divorce is not. No permanent alimony is granted.
No, yeah.
And why did she not question it then?
No, she's not unable to even not pay the counsel's fees also. She's not enough to pay one. That's what I'm contention. And one more thing, as of now, in the last date of proceedings on 30th 8 of 2024, I have filed the memo of calculation, wherein the court can produce the things that like, as of now, the arrears maintenance, pending arrears is 1,76,000. Right. So even
Any children out of the wedlock?
no issues.
On 38 kilometers, we have deposited 20,000.
I-
Earlier, on 9 kilometers, we have deposited 3,500. On 9 kilometers, that even if it's such a distance for non-person.
Recovery petition has been dismissed for non-prosecution.
Anyhow, like, no, if even if the court remands the matter,
Yes.
I don't think you will get where you will not get 5,000 is a reasonable amount. It's not your case that she's working. What will you do with an opportunity? I can understand the court grants 10,000, 15,000, then an opportunity it will. Now, if an opportunity is given, it would be more.
3,500.
Huh? You are ready for 3,500. Then how much it would be per year? Huh? 40,000. Within 5 years, this 2 lakhs would be done. And after that, when she files an application for enhancement of maintenance, basing on the other inflation and all that would be increased. How can your client say that he'll give 2 lakhs? Can you call it a settlement? Huh? We'll confirm 5,000. Why can't you pay? What do you say? Then what about the arrears? No, we do one thing. No. Whatever, first of all, let your client show his bona fides and let him pay all the arrears. Then we'll consider your request for 3,500. Whatever is the remaining as of now.
1,56,000, I think.
No, we'll do one thing.
Yes, sir.
On 3,500, whatever is the, whatever are the arrears,
Yes.
you calculate, and on that you deposit the entire amount. Then we will pass an order on 3,500. You calculate.
Yes,
We'll
sir.
pass over on
Yes, sir.
3,500 till this month. How much are the arrears you calculate?
Yes.
And we'll ask them to deposit the entire amount. Once they deposit, we'll ask them to pay 3,500.
Can you pass it on tomorrow?
Huh?
Keep it up tomorrow.
Tomorrow.
Please.
This is matter tomorrow at the request of client counsel, the respondent. Tell your client that.
Please do.
Yes, next.
Seal number 20. Sir, Gundappa.
Last occasion, you were also directed me as the website. I got it today, that it is a criminal problem.
Shall get specific instruction with regard to the proposal made by the respondent. What was your proposal?
50% of the pension was offered.
When do you want? At the request of client counsel for the petition, this is matter next week on Wednesday. Yes, next. Yes. Affidavit of assessor liabilities for you filed by advocate for petitioner. Have you gone through this? Have you served a copy or not?
No, not sir.
Served a copy or not?
And one more thing. Last time this Honorable Court directed the petitioner to produce the service rate.
When? On October. Have you seen that? The councils, both the councils shall serve the copies filed by them on the other side. This is matter on Thursday. Thursday. Yes. 22.
Seal number 20.
One, because default judgment may can be directed. Default judgment amount may can be directed to the respondent.
The amount that is deposited by the petitioner. No, he wants to withdraw, I think.
Yes, I want.
The amount that is deposited by the petitioner, the respondent is at liberty to withdraw the same.
In the name of respondent, why?
A respondent by. Yes, next.
Seal number 22. Is party.
Yes.
Wife's petition. 10,000 has been granted with us.
How much?
10,000.
Lordship, before that, this matter was referred for the mediation at the The matter could not settle when the husband was willing to pay 10 lakh to the Lordship as a permanent settlement. The wife refused to accept it and she wants a payment on a monthly basis, Your Lordship. Also, Your Lordship, there were, in the previous session also had mentioned, Your Lordship, that there was a divorce petition between the husband and wife. The petition came to be dismissed, Your Lordship. It was preferred by the husband himself. It came to be dismissed, against which he was under the impression that there is an MFA preference before the division mentioned this honorable court, Your Lordship. Although there was a number given to him, but it was not matching to his case's details, Your Lordship. We have secured the entire records, Your Lordship, and we are referring an MFA against the order of dismissal of the divorce petition on Monday, Your Lordship. So may I request Your Lordship?
How does it matter whether you prefer a MFA
Your
or not?
Lordship, in fact, the husband wanted to settle the matter.
No, that's another aspect. Your divorce petition dismissed and not MFA is on a different ground. And as far as this is concerned, then RPSC, what is the connection?
Your Lordship, you are pleased to pass an order, Your Lordship, in the same way, Your Lordship, that if there is any pending MFA.
It will be
this
connected.
this will be
Okay, anyhow, it
connected.
is not
Yes.
pending. Then we'll pass orders independently on this.
That was my submission, Your Lordship, because he wants to settle the matter, because they have been living separately since almost 15 years, Your Lordship. They are not together until there is no arrears.
Anyhow, even in the MFA, if the wife is not ready to settle, what the court can do, court can only pass orders on the merits of it.
Indeed, Your Lordship. Indeed.
Yes. What do you say?
The observation that has been made by the learned trial court, the material based on records.
You want enhancement and also the order from the date of petition. Enhancement is like how much is granted? 10,000. His income is 60,000.
Not 60,000 euros. What the material, what is placed before the learned trial court? That the material what they are placed before the learned trial court, your lordship, he was drawing a salary, your lordship. With the payslip that is 35,635 rupees on the date, and that is the material placed on record, your lordship. Now what they are saying is that, your lordship, with respect, there are 2 children born out of this wedlock, your lordship. The father was paying maintenance with respect to the girl child till her date of marriage, and also he has contributed to the marriage, your lordship. So that issue remains settled, your lordship. With respect to the male child, your lordship, since he had attained the majority, your lordship, and also now the son is also in contact with the husband, and is also finding matches for his marriages. So the, what is the contention raised by the on behalf of the wife, your lordship, that
No, the children are their majors and able to.
Daughter is married and two granddaughters are married.
What is the date of, what is the petition date?
2013.
Then we will do something, we will consider the case for enhancement prospectively. And for from 2013, we'll keep some reasonable amount because it's difficult for him to pay.
The
All the
basically
amount.
what they are seeking 10,000 from the date of petition.
That's what I'm saying. That's what we will not grant that way because it's difficult for him to pay. What is his salary in 2013?
35,000.
As per that, it was 35,000. As per decision of the petition after demand, he was gross salary was 60,000.
The material what is based on the trial court, your lordship. What has been placed before the trial court, that is 35,000.
Even 35 also, what's the difficulty to pay 10,000?
He is paying regularly, your lordship.
Where? When?
There is no arrears, your lordship. From the date of petition.
Oh, that's what I'm saying. Why not from the date of order? And according to the court, what the wife is doing from 2013 to support herself till the order is passed?
The reasoning what was given by the learned.
Because the matter is remanded by the High Court.
Your lordship, the reasoning what was the ground for dismissal of her petition with respect to her claim is that, your lordship, she voluntarily left the company of the husband.
No,
that
remains to be not there now.
Yes, your lordship. But
then it has to relate back to the date of her
yes, your
petition.
lordship. Indeed, your lordship.
So, please get instructions from your client, how much is ready to pay from the date of petition till the date of order.
Remand.
Date of order. Order, impugned order.
Yes.
Then, basing on that, we'll pass orders. And with regard to the enhancement, she is entitled. When you are having 60,000 per month as salary, as on today, we will prospectively we will pass.
But your lordship, in fact, your lordship, she is also residing with the son also, your lordship. He is also earning. This person is suffering from ailments and also he is also living separately, your lordship, and also he has to take care of himself also, your lordship. So what, as of now, your lordship.
No, we will consider all this, provided you get instructions from your client with regard to what is the amount from that date, from the date of petition till the impugned order.
Yes, sir.
And if he wants, we will give him some installment.
Yes, I'll seek
And
instruction.
but he has to.
Yes, I'll seek.
Or else if he is not coming forward, then I'll say 10,000 is from the date of petition.
In fact, Your Lordship, we came up with a proposal to them to settle the matter, Your Lordship. They are being very adamant. They are not accepting, Your Lordship.
Yes, next. Next. Next week. Tuesday. Yes, next.
May I request on Wednesday?
Wednesday. Yes, next.
Just for proceeding.
Master ordered to file the accepted liabilities bill. The submission is that, before trial court already they have filed. In fact, taking note of that, award has been passed. Where is,
PCR is there.
why he is not produced that also?
This is smarter after vacation.
Just for consideration.
Huh? After vacation. Yes, next. It's very difficult for the court last week. Yes, next.
Petition. Serial number 24, and the 24 one is like, in the High Court, 20,000 has been ordered.
You are for the wife or husband?
And for the husband.
20,000 is granted. How much is your salary?
My only contention is that she's been working as a chief data officer at Bangalore Smart City and running.
Any evidence
Yes, we have produced. And
before the trial court?
Yes, we have produced.
Then why was it not considered, let's say?
They said that it is a contract.
So, you done?
And even I think I have produced along with my documents.
And you want enhancement?
Please, in fact, what I will state was what is. Let it.
Yes, where is the finding?
RKFC, petition.
Yes.
Memo along with the list.
No, where is the, which page number, which para?
Page number 18.
No, I'm looking at RPFC 100123. Internal page.
No documents were produced with regard to before the.
But there is a-
that is what I mean. Now they have.
Then why have you not disclosed all that?
In fact, what may I say, before the marriage, he was working at BRTS as an engineer. At his instance, I resigned the job. Thereafter, after the marriage, there was a differences between the petitioner and the respondent. So, thereafter, she came back. And she joined as a contract job, and it was a 6-month job.
Was it disclosed?
It was disclosed in the proceedings itself. It's not that it was never disclosed. My submission was before the trial court was, and the evidence also led in to that aspect that I am not as a household. I have disclosed that I am doing a contract job.
How much is the salary you said?
2,000.
Now they have produced it. And
It is your duty to tell the court what was your income as on that day.
as on that date, we state that since I had resigned from the earlier job, and now for
Which
6
year
months.
it was decided by the court?
And it was.
It was decided in
May I
year
not, sir?
2000.
May I not, sir, take lordship
No,
to the discussion?
one minute, we'll go to that. This is in 2022. Rajneesh versus Neha is in which year? You must have filed your statement of assets and liabilities.
Accounts and liabilities.
Then in that, are you not supposed to disclose what is your income as on that day, whether it is contractual, otherwise or? No, if they have produced before this court, your income as on that day, which you have not stated, then are you not, are they not supposed to be a proceedings against you?
No,
For committing perjury?
So far as that aspect is concerned, the trial court has gone into that aspect also. May I not, sir, take lordship to the finding?
Please understand the court's query. I'm not looking at all at what the court said. The query of the court is, you have filed your statement of assets and liabilities before the court. In that, you are supposed to say, if you are earning, how much you are earning, and what is your requirement to maintain yourself. Now, you say that for that relevant point of time, the petitioner husband has produced before this court some evidence to show that you are earning a particular amount as on that day.
Not before the trial.
Here
they have
no,
to
let it be, but it's your duty. Are you denying those documents?
No, I'm not denying.
If you are not denying, and if you have not disclosed.
That is a subsequent development, what I'm stating. That is a
That's why
subsequent
you understand the
development.
courts. I'm asking at that relevant point of time, is it what he is relying on?
No. At that point of time, it's not, he's not relying upon. What's, there was.
So when is the petition filed? Please tell the court.
It's in the year 2022.
2022.
Please.
No, the documents that he is filing before the court and saying that you are earning, pertaining to which year?
What's now, at the present salary which he is stating that I am deriving such salary is, what is,
Which year?
establish.
It is 26, 43. It is in the judgment.
40? 40?
3, page number 43.
Para
number 35. Here in the instant case, PWM herself had made clear the producing document along with memo dated 27/6/23 issued by her employer of she is having employment only for period from 1/1/23 to 36/23 and through third viewer has produced documents along with assets and liabilities of she is having salary of 1,02,770 but has not.
So according to her, she is drawing 1,02,770. That too between for 2 months, for 5 months. So what is your case now?
My case is she is capable of earning, and now she has not been removed. She has continued in the service.
That document you have placed now before the court.
Yes,
and what is your income?
I am a doctor. I am a surgeon.
According to you, how much is your income?
Maybe one more than 1 lakh.
No, they should have been specified. You must have stated so. How much is your income? Where is the discussion? Where is that?
The court has discussed
about your income.
So the court has come to the conclusion at number 50, madam, page number 50, on going to the principles and consider the financial status of RWR.
No, where is the financial of the husband that we need to look at? Which para is the discussion about your income?
41, 50 page number 50, para number 41.
No, that I have seen. Court only gave 20,000. Where is the discussion about your income, husband's income?
Para number 38 of the order.
Please. PWM in order to show that RWM has got sufficient means to provide maintenance and sought by her has produced the renewal of contract issued by Justin Denmark, Exhibit PP, which indicates that net payment is rupees 1,82,250 as on July.
So, when you are earning 1 lakh per month, husband is earning 2 lakhs. What is the necessity for maintenance?
May I state not, sir? I've got a document now, not, sir. Since it's a contract job, and it's a renewal by way of.
It shows you are capable of earning. You are earning.
But, that is not. I am not disputing that I am earning now. I am working. What's the judgments which have been come by the dishonorable court and also yes, in instances have held that even though she is capable of earning, she can claim maintenance. In fact, in this.
No, there are two aspects. There are two aspects here.
Please.
Capable of earning, not earning.
Please.
Capable of earning, earning.
Please, I will prove. I will demonstrate the conduct of the respondent here in Lord's husband. What he is doing now, Lord's with respect to the job is concerned. I got a document. Now this project comes to an end by March 31st, 2025.
How did you know?
Please.
You filed this enhancement petition when?
Lord's, we have claimed the maintenance of rupees 50,000.
No, when
Yes.
you're having
Please,
an
Lord's,
amount,
I'll
income
say.
of 1 lakh, why do you want another 50,000 from the husband?
Lord's, Lordship.
Do you have any children in the background?
For a moment, Lord's, for a moment, Lord's, I filed an affidavit to that effect. That on earlier instance, in this present petition itself, there is an order for Lord's by the Honorable Court to both the parties to consider the settlement. I mean, rejoining the marital life. Some incidents have happened. By way of affidavit, I have put it. Kindly look into that affidavit. What has happened thereafter? That is why I am claiming. That is why I am claiming enhancement principles. Kindly peruse the affidavit for a moment. Lord, sir.
Let it complete from here.
Earlier, there was an instance of abuse and assault on part of the petitioner wife. In spite of that, she rejoined the petitioner as per the direction of this honorable court. At the time of the rejoining order also, the petitioner, the respondent wife misled that he has left Mysore. First, he was initially working at Bangalore. Then he told that he has shifted to Mysore. And then he said that he has come down to Shumaga. And thereafter, may I for a moment, thereafter, she visits the house of the husband. He doesn't intend to take her back. He puts some condition that which I, by way of affidavit, have stated. And also, Lords, after that, he makes an RTI applications to my office, one anonymous letter and one directly. With the intention to see that the petitioner is removed from the job. Such conduct is not appreciable at all.
Why will they remove you?
Please, kindly see the RTI application which I have produced. The tenor in which the RTI application has been made. At the first instance, during the time of marriage, I have resigned at his instance. Now he is creating a problem with regard to now present job also.
What did you do? What did he do?
Please, page number 6 of the RTI application. It's styled as the one application filed by one RTI activist. May I read this affidavit, please?
No. What you want under this RTA is your job details.
There are lots at the instance of the very husband. There are various litigations pending. In fact, due to the abuse and assault made by him, there are criminal cases pending. Now he has filed divorce petition, though he is staying at Bhadravati, falsely claiming to be staying at Bhadravati. Now he has filed a divorce petition at Dharwad. All my salary goes with the handling with these litigations, and he is making an attempt to my office to see that I am removed from the office and the current job.
What happened to the divorce proceedings?
Sorry.
What happened to the divorce proceedings?
Divorce proceedings, now they have instituted it. I have to appear and file objections to it. That too, it's been filed in Dharwad to see that he knows that I'm working at Bangalore. He is also a resident of Bangalore.
Nevertheless, you can see transfer of it.
That is also filed, so I will take up that matter. But the conduct of the respondent doesn't.
Please understand. We are now on the point. I can understand if you are looking at the divorce proceedings or any other thing. Now we are on the maintenance aspect. When you are getting 1 lakh rupees as salary, why you want maintenance?
No. It's a contractual job.
You are having 1 lakh in hand. Why do you want maintenance?
It's a contractual job. It's coming to an end by April.
You will seek maintenance on a anticipated on the anticipation of your
not an anticipated. It's a contractual job which comes to an end.
Right from 22 to 2024, you're working there.
Very good.
In the same place.
That is there, that is not denied, bros. That is not denied. I'm not denying that aspect. But the conduct of the respondent.
Leave it open. When you don't have a job, ask for maintenance.
My respective submission says the conduct of the husband is also to be looked into when he is not ready to get back the wife and doing such a thing. That cannot be a ground.
If he says that the wife without a reasonable cause is staying away from him, then we will look into this conduct and grant maintenance. Now, in this is a case where maintenance is not something that just like that the wife will ask the husband. The purpose of granting maintenance is about her that she should be taken care of, like her basic needs and whatever that some other judgments with regard to some other parameters. But in these facts and circumstances, a lady who is earning 1 lakh cannot ask for maintenance.
And this, with respect to submission, my submission is that when a husband shows a conduct to see that the husband, the wife doesn't.
No, please tell the court. If you don't tell the court, if you are not telling the court, saying that mine is a contractual job, what is the option left to him to find out and tell the court that you are continuing in the job? Is he not supposed to ask your employer?
No, it's not that I'm saying that you should, you should not take.
22 is the petition. That day you say, I'm only for the 4 months I worked. We are in 24, you are still working. And you know, you've not stated all these facts. And you seek for enhancement.
I'm not, it is not
You
that
seek
I'm
for
not,
enhancement.
it's not that.
In
I'm
your
saying.
enhancement petition, let us see what it is.
Please.
Let's see in your enhancement case, what are the grounds that you have stated? So, let's see. Huh? No, before that, let's see what is she said in the grounds. Why you are seeking enhancement? Where are they?
Start from para number. Para number 33, no?
No reasons. Just like that you asked 50, court I granted 20, that's why you want.
But
And
sir-
what are your expenditures?
Yes.
What are your expenditure?
Expenditure notes, I have to stay at Bengaluru notes. I have to handle the litigations instituted by him. At his instances, all has constructed.
No, not a general
And-
statement. As per the statement, what is your salary? What is the requirement? Do you have your statement of assets and liabilities with you?
No,
that
no,
are
sir,
filed before the
which
court?
was filed before.
Do you have the registry is directed to call for the record? This is matter after vacation. Yes, next. Yes.
One petition, wherein the family court had directly to pay us 20,000 per month. There is no issue out of the
How much is your income?
My income is I'm working as
Inspector, how much you're earning?
upon the date of filing of the petition, I was having salary of around 72,000.
Huh?
72,000.
72,000.
But before that, I would like to know, since
Is the switch on of the mic? Or why is it not audible? Yes.
The early allegation, this court had had a discussion in the chamber, and I am ready to take the wife back. And accordingly, as per the direction, I visited the house of the respondent. And after that, she was supposed to come and drive the wife. She was insistent that I should work at Hubli only, where she is residing.
Or she will give you a job at Hubli. How can you work at
No, she
Hubli?
is not working.
When he's an inspector, as per the
No,
transfer, he has to.
that is not the court has this
I
court
further,
has
further, and the instruction of the order of oral action. I have given 1 lakh what she had asked on that day. Within 2 to 3 days, I have paid 1 lakh to her account. That's interim maintenance was regularly was paying. After that, before 2 months initiation of proceedings, she had filed 4 and 8 proceedings against all the family members. To which I have my promotion is halted. DPC is under process and I am not eligible for the reason that sure.
No,
That is apart from that.
No.
That's what I have. My
Divorce proceedings are pending.
divorce petition not filed.
And then.
It has one. Only maintenance petition which was filed by the wife was under challenge.
So what are the settlement talks?
Settlement talks, I am ready to take her back.
What is our
Now
case?
she is telling that I should come. As per the direction, I had been to their house and
Ask her to
had
come. What is it she wants? Is she ready to join the husband or not?
join the husband, but as per the court order dated 25/9/2024, the husband has to take her to her workplace at Gulbarga, Gangavati, and he has to come and take her. Date was fixed, and on the particular day, he has not turned up. Till today, her husband has not made a call. Only the advocate representing the husband was.
Let the husband come, where is he?
My submission is.
Where is the husband, where is he working?
He is working at Koppal district, No.5.
Ask him to come on, come before the court on Tuesday. Let her also come. Come before both the parties shall appear before this court on Tuesday. This list is there.
On Wednesday.
Huh?
On Wednesday.
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 Yes, next. Huh?
In chamber.
No chamber, in the court. Yes. Inter-alia granted is expedient till then. Yes, Wednesday, let her also be present on this. And later, your client don't try to be too smart.
No, as per the direction, I listened. I came from Dharwad and I had a cup of tea.
No, she is ready to go.
She is ready to go, but
Yes.
the husband has not made a call, single call from husband. She has tried to call on 9/10/2024,
And
10/10/20.
he will take her on Wednesday. He is coming.
Yes, please.
Yes.
Let her be prepared for that.
Please.
Yes.
Not paid.
On the last date of hearing was 30,000 was paid. Today not.
Where is the counsel for the respondent?
40,000 is paid to her. Today 40,000 is.
When counsel the petitioner submits that an amount of rupees 40,000 is paid to his arrears. No representation for the respondent and the parties. Have you received 40,000?
Today as to the account it is deposited during working hours. We must not.
The no representation for the respondent. List is matter after vacation.
Please.
Yes, next.
Here to respond in minutes.
What is this non-filing of memo of acknowledgement? Paid?
Next, the no instruction regarding the.
As for the order, and counsel submits that as for the orders passed by this court, he has deposited the amount and the respondent is at liberty to withdraw the same. This is matter after vacation. Yes,
Let's
next.
move it. One submission minutes. In the meanwhile, minutes, the petitioner husband may be directed to disclose his assets and liabilities.
The petitioner shall file before this court, both the parties shall file before this court, the statement of respective statement of assets and liabilities. Yes, next. Inter-alia granted is extended till then. Yes.
We have to petition the first matter. 10,000 payment. Court had ordered for an interim direction wherein 10,000 monthly should be paid to the wife. Receive 10,000.
Court said you have to, when the matter came up, and counsel, the petitioner has handed over an amount of rupees 40,000 by way of cash to the counsel for the respondent.
By way of meeting order, 20,000 is released and 50% was answered.
50% is how much?
10,000 per month.
Oh, on that, how much is 50% of the arrears? Sir? What are your instructions?
I have received the instructions that he has to pay more than a lakh. Calculation was given.
The counsel to the petitioner has handed over an amount of rupees 10,000
Now he is
to the counsel appearing for the respondent. The respondent by the next date of hearing shall place before the court
Receive some 9 lakhs.
what are the arrears of maintenance and shall file a calculation memo by serving the same on the counsel for the petitioner. This is matter on after vacation on the 14th or 15th. Inter-alia granted is extended till then. Yes, next. Transfer from where to where?
Kudum to Downhill.
What's the distance?
Downhill.
Distance.
It's a 200 kilometers.
Which year is the MC? Which year is the MC?
2022.
2022.
Yes, sir. State is Euro state law.
So what is to be done now? No interim order in this.
Yes, sir.
Please come. The present petition is filed seeking transfer of court officer. What's happening in the court? MC number 57 of 2021, pending on the file of the senior civil judge JMSC Kudlagi to be transferred to the Family Court Davangere. This is a CP of 2023. When the matter came up on the query from the court, then counsel for the petitioner submits that the matter is at the stage of evidence, considering the fact that this is an MC of 2021 and already as it is at the stage of the evidence, this court is not inclined to consider the case of the petitioner. However, it is left open to the petitioner to make an appropriate application before the trial court for seeking expenses for the travel on each date of hearing accordingly disposed of.
One baby will also be, one baby will also 2.5 years.
But what are you doing? That is the whole issue.
Long distance process.
But you kept quiet. What to do? Now the court has already spent enough time on your case. It can't be. That's why I said your expenses. You please ask from the court. Yes. What are you doing in a 2023 matter? Even till 2024 also office objection stage. Then if you are not interested, we'll dismiss it. Why have you not complied till now? Finally, a week's time is granted. If the office objections are not complied with, the petition shall stand dismissed without further reference to the court. Yes.
Translation copy.
Yes, translated copy. What is the revision about?
This revision petition is filed by the unsuccessful decree holders before the court. They have filed an application under 21-32 for execution of the permanent injunction decree. In fact, in OS number 34 of
The court had dismissed it.
no, suit was decree.
This the decree holder's petition for execution on the ground.
On the ground that these
When is the injunction decree? When is the decree that is passed in your favor?
yes, passed in favor of the present resident petitioners
Yes.
on 22/2014.
22/2014. Yes.
In OS number 34 of 2011.
It has a 10 penalty.
Yes, thereafter, the present respondents, who are the LRs of the defendant number 1 there, they preferred an RA. That is annexure C medals.
What happened to that?
That also came to be dismissed and
On?
thereby through a judgment and decree 24/2/20.
Then
Thereby, this suit came to be
allowed.
finally disposed of. And these respondents, they have suffered the permanent injunction decree and also a declaration that they are the owners of the plot.
No, you said injunction. Suit for injunction.
Suit for declaration and injunction.
Oh.
Yes. And in respect of that, thereafter, they try to construct a hut in our property. Hence, we wanted to execute the decree. Hence, filed the application on the 21/32. But the trial court, in para number.
Let's see the impugned order.
Yes, madam. Only short, para number 11 matters.
Oh, para number 11 of the impugned order, which you have filed the translation.
Yes, I have produced. In verbatim, I have translated it. Para number 11.
Please read. Let's read from the reasons.
May I read para number 11 minutes?
Yes.
The order of permanent injunction is right in persona but not in rem. The defendants 1 and 2 in original suit number 34 of 2011 have filed. The judgment and decree.
You are saying that it is not an injunction, it is a declaration and injunction.
Madam, it's a declaration and injunction suit. And these respondents, being the LRs, prefer the appeal. That appeal came to be dismissed. Now they have suffered the decree. Because RA is the continuation of the suit, madam.
Yes, the learned counsel for the petitioner submits that when the petition has filed the
And another thing is,
has moved the execution proceedings, the court had dismissed the same. That the order of permanent injunction is right in persona, but not right in them. And the defendants 1 and 2 in original suit have died. The court observes that they have not mentioned the specific time and place and also which of the opponents have violated the said order. Such facts have not been proved by the applicant, sufficient evidence, and accordingly dismiss the same. Learned counsel for the petitioner submits that the court, without consulting the application, had no, there is no. This is your EP itself is dismissed.
EP itself was.
Then notice to the respondents, no order is required. Notice to the respondent.
And in fact, we have closed the decision of apex court.
Let them come because notice has to go.
Yes.
The notice to respondents, petition is formed. There is nothing pending, so then we'll order that.
Yes.
The registry is directed to issue emergent notice. Yes, next 32.
Okay.
Huh?
I'm afraid for diamond Bhatti.
Huh.
Please, ma'am. Salary certificate directed to produce salary certificate, my lord, and produce
No
the
representative
salary
is
certificate.
submitted that the council of petition is not filling well. This is matter of revocation. Yes, next. Yes. 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 Like both the council submitted the settlement
Request,
officer.
madam, the amount was deposited.
Both the council submitted the settlement officer going on. This is matter of vacation. The respondent is at liberty to withdraw the amount deposited by the petitioner. Yes, next. Promoted order granted is extended till the next date of hearing. Yes, next.
Section 34.
Respondent is already adjourned.
My lord, 34, my misleading me, physical adjournment volume. I asked him about the procedural citations. Last time also I have taken the procedural citation. Both sides have argued the matter. Citations on the last 27th to time holder.
He didn't even mention to you.
No, morning I have asked him about the citation. I have produced today. Hey, one mislead my time holder.
No. He said he has informed you. Has he not informed you?
No, not informing me. I came from
List
the
34. List this matter tomorrow. Learned counsel appearing for the year for the petitioner.
petition.
Submits that without even informing to him the respondent had taken time. Yes.
Can you extend the interim order?
Interim order earlier granted is extended. Yes, next. Yes.
Petition by White.
Seeking from transfer from where to where?
From Dharwad to Dharwad.
What's the distance?
200. 220.
MC is of which year?
MCR is 2023, my lord. No, my lord, in the year, my lord, interim order is granted, my lord, on 23, then 2024, my lord.
By that time, what is the stage of the proceedings?
By that, my lord, for appearance of the wife.
Shall I record that? Or you want to place the proceedings?
My lord, I have placed the proceedings
Where is that?
at the, my lord, in page, my lord, 24, my lord. 23 and 24, my lord. My lord, last 7 months I got interim. However, my lord, he has refused the notices, my lord.
Let's see. Let's forget about him. Let's see what are the proceedings.
23.
20?
In page 23.
Notice to respondent, call out absent, placed ex parte or ex parte,
Thereafter, my lord, I have appeared, my lord.
and that already set aside.
Yes, my lord. MTM order, my lord, I have produced thereafter, my lord.
No. This is your place of proceedings till what date? 27, 23 to 2024.
25 1 2024.
When is that? That's what I'm saying. Interim order is granted when?
My MTM order is granted on 13/11 to 12.
So what has happened between first month and the end of the year?
My lord, 24/1/2024, my lord. PW1 is absent, my lord. Appearance for PW1. That is, lord, on leave is 24, my lord.
When is the interim order granted? Please tell the court.
MTM order is granted, my lord, 13 on the month of February, sorry, 1/3/2020.
That's the confusion you are creating.
Yes, sorry, 1/3/2020.
Please come. The present petition is filed, seeking transfer of MC number 46 of 2023, filed by the respondent for restitution of conjugal rights, pending on the file of the senior civil judge JMFC. How do you spell it?
200.
Pending on the file of so and so to the family court at Dharwad. The facts of the case are: on 22/5/1994, the marriage had taken place between the parties. In view of the it is stated that because of the in view of the behavior of the husband, the wife had to leave the matrimonial home, and she had filed criminal miscellaneous number 166 of 2022 before the family court Dharwad, seeking maintenance. Thereafter, on 29/2018, the husband has filed MC number. It is 29 to 2023. The husband has filed MC number 46 of 2023, restitution of conjugal rights and counsel appearing to the petition submits that the distance between both the places is about 200 kilometers. Any children out of in the wedlock?
Yes, ma'am. 3 children. 3 children.
Then the wife had to take care of 3 children. It is submitted that it's very difficult for her to travel 200 kilometers and sought for the transfer of the petition from so and so to so and so. The next para, notice to respondent. As per the order passed by this court, the petitioner had taken out the notice on the counsel appearing for the respondent before the trial court.
No. Yes, we refused, my lord, because of the file memo, my lord. Thereafter, my lord, I have taken such steps.
Thereafter, as the counsel has refused to receive the notice, and the notice that is sent to the respondent returned with the endorsement unserved, this court had directed the petitioner has permitted the counsel to take out notice in the criminal miscellaneous case where the respondent is appearing through a counsel. Where do you get that it is refused?
My lord, I filed a memo, my lord, to that effect.
Then when did the court recorded that?
On that day,
No, there's nothing.
My lord, on 23/10/2024, my lord.
23/10/2024,
my lord.
No, you're permitted to take out. It says it is served.
Served, my lord, fresh notice, my lord, on 26/11/2024, my lord. I have taken fresh steps.
To whom?
Where, my lord, he is serving, my lord. To the respondent only.
The notice.
Where he is working, my lord.
Notice that is sent to the place where the respondent is working as per the postal track. It appears that the item is delivered Hence, the item is very Next, considering the submission by the council and the fact that the distance between both the places is about 200 kilometers, and as per the order passed by this board, the proceedings were stayed from March 2024, and considering the interest of the wife and the three children, the this court deems it appropriate to allow the petition. Accordingly, so and so is withdrawn and transferred to so and so.
So number 36.
Lot 36, I appear for the respondent.
Yes.
This is Jnanaya Swami.
Yes, what are the?
Senior counsel is appearing to PC minutes.
I can see here.
But 7 Rule 11 dismissed. I am the plaintiff seeking specific performance. Petitioner.
I am there
Yes.
for the petitioner. Let me
Yes.
make a submission.
Yes.
Yes.
Mother, the sole defend,
Yes.
may I make submission?
Yes.
The sole defendant in the suit filed by the respondent plaintiff is the petitioner before your lordship. I would request your lordship's kind attention to page number 19. As to, of showing as to what is the prayer made in the suit. It's a copy of the plaintiff I'm referring to. I'm referring to the prayer made in the suit.
Yes. Yes.
May I read with your lordship's permission? Wherefore, in the light of the above, this honorable court be pleased to direct this suit of the plaintiff and direct defendant to execute a joint. The decree is for a direction to me, the petitioner, to execute a joint development agreement in the respective suit scheduled properties as per MOU dated 12/3/2021. Well, it's the very outset. Without going further into the matter, I would respectfully submit to your lordship that the matter is fully covered by the Supreme Court judgment in 2009 1 SCC page 425, which says that there can be no special performance under section 14C of the Special Credit Act for the direction to execute an agreement in pursuance of a MOU. That is fully covered by the judgment.
Which para?
I take your lordship to paragraph 22 of the citation.
Such a contention was never taken.
Yes.
Para 22.
Yes.
Yes. But I'm sorry. Just point me. Is it green paper? Yes.
For a moment, Lord, this ground was not raised.
Just 1 second.
In the IA and Order 7. Let senior counsel.
I was just keeping here. Yes, I'm sorry. Here, the ruling is 2009 volume 1 SCC page 455. Paragraph 22, my lord, is the relevant paragraph which refers to the settled position in law. That was a case where a tripartite share purchase agreement had been made. Firstly, my lord, for commercial agreements, there can be no special performance is settled principle. Now, my lord, I am referring to para 22 for a minute. May I read, ma'am? Para page 481. Enter into another agreement because it is provided that both parties agree to have a set of deadline to file this by 15/9/2000. Next one, ratio decidendi is here. It is just a legal position that an agreement to implement an agreement is not enforceable, nor does it confer any right to the parties. This being the position, that is it is I straight away read to your lordship, the prayer made in the suit is that I should be called upon to execute an agreement.
Let
No,
us see where is agreement?
pardon me.
Where is that agreement?
That application has been rejected. I thought that there is no cause of action, there is no privity of contract, there is no signed agreement, and the prayer itself is for execution of an agreement in
No, no,
pursuance of the MOU.
where is that agreement?
The first annexure, Lord. First annexure. The
Yes,
very first annexure. MOU.
yes,
MOU.
Dated 23/2/21.
yes.
Go to the MOU. It may-
And in the second page, fourth whereas clause contemplates further arraignments, which we have sought, on which we have sought specific performance. The second page, fourth whereas clause.
Mr. Reddy Garu, can I make a submission?
Yes, sorry, sir.
Sorry.
Sorry,
Page
sir. Sorry. Please.
No, not at all, not at all. I appreciate you. Page number 66 may kindly be seen. The very first term or very first clause contained in the MOU is this. I will read you. The owner, first party, that is the present petitioner, and the developer herein explicitly agreed thus that this memorandum of understanding is valid from the date of the execution, signing on this memorandum of understanding by both the owner party and the developer builder second party up to legal clearance by obtaining all the required certified copies and documents pertaining to scheduled property. And verification is done in legal.
Before we go to that, please point out where is that IA and the affidavit and the grounds that are raised in support of the IA. Where is that application?
In the petition,
Which is the clause. That agreement having not been executed by me, this present suit has been filed, and as I have already pointed to your lordship, the prayer in the plaint in the suit is at page number 19, decree the suit of the plaintiff and direct the defendant to exit.
No, filed an application under order 7 to 11. Where is that IA?
Wait, I will read. IA at page number 22, Malad. Page 22 is the IA, 23, Malad, there is the affidavit. I will just read. In fact, active para 3, Malad, page number 23 may kindly be seen.
Yes, let's see.
At the very outset, I respectfully submit that there has never been a privity of contract between me and the named plaintiff, and the professor memorandum of understanding is not a contract whatsoever, even as the plaintiff has itself quite clearly stated by seeking from this honorable court a direction to me to execute a joint development agreement in respect to the properties mentioned in the stale, inoperative, inchoate memorandum of understanding. Next one, para 4. It would at this stage be quite relevant to submit that no concluded agreement or contract of a binding nature has ever been entered into between the parties to this instant suit, and hence, in the absence of any concluded contract between the respective parties, the instant suit is grossly misconceived and besides being so and so. Another, I would request your lordship's kind attention to just to skip over for a moment. I will read the further portions of my opinion. But I have a very passionate request that your lordship may kindly go to paragraph 18, which is an admitted fact, which para 18, page number 18, para 12. I made a mistake. Page number 18, para 12. I'm reading from the plain.
Yes.
About 6 sentences. It is submitted, may I read? It is submitted that the plaintiff is seeking the relief of specific performance of its rights under the MOU, and since there is no consideration mentioned for execution of video, the relief sought by the plaintiff falls in. The fact that no fine, not even a copper coin, was paid under the MOU, an agreement without consideration is void, is the basic concept of law of contract as well. Lordship is well conversant with. I need to. Now, my lord, MOU dated 12/3/2000 said that I must execute a joint development agreement. The settled position in law, just at the very beginning, I read out to your lordship that to execute an agreement, there can be no suit filed. Therefore, the plaint ought to have been rejected. By a very strange reasoning, the court below has rejected the application without considering any of the points that I argued. I would request your lordship to pay attention to the impugned order, which is the remaining portion is page 57.
What the parties to the suit?
Yes, ma'am.
What the
The
parties to the suit?
page number 57. Ma'am.
So, let's look at the memorandum of understanding.
Yes. I will read para 2. The defendant
In a very
permitted. The defendant has contended that the said memorandum of understanding has no consideration and therefore does not form a binding contract between the plaintiff and the defendant. It is further contended that the plaintiff has not paid the proper court fee so and so. The plaintiff has filed objections to the aforementioned application, denying the averments of the defendant and contending that there is a valid, binding, and concluded contract between the parties. Kindly permit me to digress for a moment. If there is a binding contract, he should produce that contract. The prayer is for entering into a contract. No person can be compelled to enter into a contract.
Give the
Then
court
it is
1 minute time. Just look at the memorandum of understanding, what it says.
therefore
Yes.
Yes. Now, I request your Lordship's kind attention to page 60 for a moment. Well, here is a case where not only an application was filed, written submissions were also made along with the citations. I request your Lordship, page number 60, to buttress the submission that a large number of binding precedents were cited and the copies were furnished to the court. The court does not even make a passing reference to any one of the judgments, but it's a cryptic and laconic order by brushing aside the argument. Page number 60, the defendant has relied on the following decisions in support of the case. Then there is the principles laid down in the aforementioned decisions. This is all what it says. Therefore, in reiteration of what has been argued before the court below, I would say that these judgments would require to be considered. And one of the points that have pointed out as a preliminary issue was that the matter is concluded by the judgment of Supreme Court in 79-1 Supreme Court, where it says that there cannot be a excuse for enforcing an agreement. Therefore, for execution of an agreement, in pursuance of an agreement, here there is not even an agreement, it is a MOU. Therefore, in the wake of the concluded position, settled position, the trial court was not justified in ignoring the binding precedent under Article 141 of the Constitution. It's my first submission. Now, Madam, kindly go to page 62 for a moment.
Yes.
Then, para 16. It is said a specific contention of the defendant that the memorandum of understanding dated 12/3/2021 is not enforceable as it is not a valid contract. The nature of the document in question and whether it forms a valid contract.
Your order, Mr. Senior Counsel, will ask Mr. Vivek. Yes. Yes, Mr. Vivek.
Yes, Lord. Lord, they kindly see, Lord, the MOU. The second page of the MOU.
No, where is the consideration of all the judgments that they are relying on? No, they say that MOU, according to them,
actually, yes, Lord, they raise 2 points, Lord. One is no consideration, other is not enforceable. On this, the learned judge answers very clearly. Can kindly consider, Lord, paragraph number in the judgment. Both these contentions are considered. Section 14E that learned senior counsel is raising is raised afresh for the first time now. This, Lord, so far as non-enforceability, and it is Yeah.
No, no, if you look at the application that is filed under Order
Yes.
7 to 11, therein,
Yes.
that's what I have seen it. Therein, they
Yes.
clearly say that that is not enforceable. For seeking enforcement of such MOU, a suit is not
Yes.
maintainable is a principal contention.
Correct.
For that, you don't
Yes.
require any evidence under Order 7 to 11. And the court has to settle legal position. Do
Ah,
you have any other
Lord,
judgment?
there are almost 8 judgments. So 8 judgments which say that a MOU is enforceable.
Then please place all those. We will
1, 2, 3, 4,
consider.
5, 6, 7. 7 judgments, Lord, which says MOU is enforceable. And these 7 judgments, this is held by the Supreme Court that whenever an MOU is entered into with a further contemplation of a registered deed or a development deed, then these deeds, this MOUs will be enforceable. There is no bar in law.
Where are
And
the copies?
unfortunately, my Lord, they have not been able to point out any provision which bars the institution of the suit. They have not been able to point out.
No,
And
no.
7 Rule 11
No, in that.
arises under
No, Mrs.
arises under 2 circumstances. One, there must be a explicit bar.
Correct.
A provision must say it is barred, but there is no bar.
No, no. In that case, the court should have stated so. The court should have recorded the reason that the contention that is raised by the defendant is not correct in the light of the settled law. No, it is. But the court has mechanically says that this is not the stage when an Order 7 Rule 11 application can be considered.
Kindly see 16, Lord, para 16 of that order.
I read that. It only says
Yeah.
that at this stage it cannot be.
Yes, there are 2 contentions raised by them, Lord. One is consideration. On consideration, it is an acknowledged aspect in contract that consideration need not necessarily be money or future sharing. Yes, a future share. Yes.
Legal point.
Yes, the legal point as to whether MOU is enforceable or not. That's the issue that your lordships are asking.
And there has to be a reasoning for that.
Yes. No, what they say is, kindly see 16, Lord. What
Yes.
they are saying is, MOU is not enforceable as it is not a valid contract. Now, yes, I'm just expanding on that issue, Lord. Now, if their contention is the MOU is not valid because it is not a valid contract, it hits at the formation of the contract. What exactly they are saying is because they were introduced to the promisee on that day, therefore they did not know about this MOU. That is what they are saying. That your lordships will get. Kindly see, Lord, the IA.
No. Please understand.
I'll just point out that, Lord, why they are saying that. They are not saying that.
I have read what the court is saying is, they have raised 2 contentions with regard to the consideration, other is with regard to the enforceability. The court, on the question of enforceability, the finding of the court under Order 7 Rule 11, it cannot be considered, is not the correct reasoning.
No, Lord, the ground.
Disparity. The court relying on the judgments which you are relying on, saying that it can be enforceable. If that is the reasoning given by the court can understand.
No, what I am trying to point out is, Lord, the point is this. A slight, subtle different from what they are arguing. What I am trying to say is that their contention in the 7 to 11 application is that it is not their contention that MOU as such is not enforceable. That's not their contention. Their contention is, let me just clarify. I can take your lordships to the pleadings. MOU, they are saying MOU is not enforceable.
Let's see the application. Order 7 to 11, let's read together.
Para 6.
Page number?
Page number, Lord, I don't have the entire compilation. I have the para 6 of the application. They have not given me the compilation, but they have not given us the compilation, but we just have the petition copy, but we have the IA here. Para 6 of the IA.
23.
Yes.
Kindly see para 6.
Yes.
They say at this stage it would be relevant to extract the contents of the para 3 of the reply notice. At the outset, it is made clear that my client had talks with M.R. Hiremat, retired KS officer.
Para number 4, read from para number 4.
It would at this stage be quite relevant to submit that no concluded agreement or contract of a binding nature has ever been entered into between the parties to the instant suit, and hence in the absence of a concluded contract between the respective parties, the instant suit is grossly misconceived. Besides, that is a triable issue. When 2 parties have signed this agreement, and there are certain terms Whether the terms can be put into specific performance or not is a tribal issue.
No.
It is not their case that an MOU as such
Along with the
is not enforceable.
No. Along with the plaintiff, they
Yes.
filed the MOU. While
They
considering
filed the
application, they filed the MOU.
MOU, yes.
So while considering an application under Order 7, Rule 11, court can as well look at the documents that are filed along with the plaintiff.
Correct. It has to be seen. Yes, ma'am.
According to them, MOU is an unenforceable document and seek a specific performance. For that, they are relying on some decisions. You are also relying on some decisions saying that even on an MOU can be enforced. Then what should be done by the court?
No, it was not their case.
No, the court should consider your judgments, their judgments, and how that applies to the case, or it do not apply. The court has to decide it. Court simply cannot say it is a tribal issue. No, if on law, if the suit is hit by any law, that has to be decided under Order 7, Rule 11.
Lord, on this, kindly see para 7. That clarifies the position. The
7 of
application.
what?
7 of the application.
Yes, let's
7. Such being the incontrovertible and undisputed fact, am I reading the same place? That there was no kind of consensus addendum between the plaintiff and me. The professed MOU, which is a void ab initio, has not conferred on the named plaintiff any kind of right. Now, if the nature of the contention is not a legal question, that MOU is enforceable. What they are saying, Lord, is a factual aspect that the professed MOU has not conferred on the named plaintiff any right, and there is no kind of consensus addendum. Not consensus addendum. Whether there was a consensus addendum is a mixed question of fact. Is a question of fact. Whether there is a consensus addendum.
No. When you look
and
at
that's why they say it has not conferred any right on the plaintiff. Lord, how would it be?
You have to read 4 along with 7.
Lord, even if we read 4 along with 7, and kindly read 6 also. What they say? Why they say there is no?
No, Mrs. Subbarati, court is only on one point. Now,
Correct.
the reasoning, the order impugned is bereft of reasons which the court should have exercised.
Lord, even if we take, Lord, for a moment, Lord, even if we take para 4, it would be quite relevant to submit that no concluded agreement or contract of a binding nature has been. This is a question of fact.
It's not tribal.
Whether there is a concluded, where have they said, Lord, that if a document, Lord, just a moment, Lord, just one point just one point I'm placing, Lord. Where have they said in very clear terms and explicit terms, very clear, very transparently, where have they said that the MOU per se, a document styled as MOU per se, is not enforceable? They have not said it anywhere, Lord. They are only saying that there is no concluded contract, there is no consensus addendum. If it circles around this controversy, it has to enter trial. Because parties' names are there, their signatures are there on the document.
No, that is one aspect. Is it the reasoning given by the court?
Lord, then they can file a separate application, Lord.
No.
That liberty may be reserved. If they want to contest that an MOU per se is not enforceable as a question of law, they may be given a liberty to raise that question.
We'll do one thing. What we will do is, we'll set aside this order. We'll remand the matter to the court. Whatever you want to raise, what they want to raise, let both of you raise, and then let the court.
One issue is that in the application that is already raised, this question is not there. Now, if they want to raise this question, they cannot change that application now, Lord. They can raise this question in a separate petition because issues pertaining to formation of contract are essentially based on trial. Court cannot conclude at the preliminary stage. Now, Lord, your lordships may make it clear that if their case is that an MOU per se is not enforceable, it can be raised.
No. Because
this order can be upheld.
No. Because without going into any of the aspects, when the court says that so many judgments are relied on by you and by them, where is the reasoning? Where is the constitution?
Well, those judgments do not touch upon the MOU enforceability.
The court should say that.
No, that issue was not raised. That issue was not raised at all.
The court should apply its mind to the cases cited by me. Not even a reference is made.
Yeah.
Just
So judgments before me, I will not say that I won't even record what is. No, whenever you rely, the court will say that he is relying on so and so. As for so and so, it is not applicable or replicable. That's the duty of the court. That's the duty of the court to give reasons.
No, Lord, if suppose lawyers, we are prone to filing a number of judgments, some may be relevant, some may be irrelevant. Now, if the court feels it is irrelevant, Lord, it did not specifically say
No,
that these are the judgments.
no.
Only thing the court has culled
Go
out
ahead.
very clearly. Yes, sorry, Lord.
No,
The
you will
court has
not.
very,
No,
yeah,
no, no.
court was,
If your judgments are not considered by the court, then you will ask the court, I have relied on, why the court is not referring to them.
Lord,
We
court,
do that.
when there is
May
no fundamental plea in alignment with the judgment. Actually, MOU enforceability is a new ground raised in this petition.
no.
It was never raised earlier.
I'm
By
extremely
Lord,
sorry.
para 4, which your lordships are indicating, is
I would not
ultimately the
interfere.
consensus addendum issue, which is a
I
tribal
would
issue.
not. It is not my habit of
You could
interfering
have
with.
called us after lunch.
But,
Signatures.
Ordinance one of serial number 38, which may kindly be taken from independent after.
Why proceedings now? We'll see in the afternoon.
ಪಂಚೆ ಉಟ್ಕೊಂಡು ಏನೋ ಹಾಗೆ ಬಂದಿದ್ದು
should have. Also,
Continuation.
seal number 36.
Shouldn't make a mention of, should have been in the morning. You appear for whom? 50? 56, at the request of one counsel, the petitioner, after when? Call the continuation.
Seal number 36.
Please, Your Lordship.
The present revision is filed. Agreed with the orders passed in I number 4. Invoice number 803 of 2022 dated 1/4/2023, whereby an application filed under Order 7 to 11 is dismissed by the trial court. The respondent therein has filed a suit seeking the relief that the seeking a direction to the defendant to execute a joint development agreement in respect of the suit scheduled property as per the memorandum of understanding dated 12/3/2021. It is a specific case of the plaintiff that the defendant is the owner of the property and they have entered into a joint development agreement with the defendant in respect of the suit scheduled properties, which empowers the plaintiff to develop the properties into a residential layout according to plans that would be approved by the competent authority. And as per the memorandum of understanding dated 12/3/2021, the defendant has agreed to execute it is agreed that the ratio of the scheme shall be 45 to 50%. That is, 45% of the developed area would be allotted to the defendant and the 55% to the plaintiff. As per the MOU, the defendant has to execute a joint development agreement within a period of 3 months from the date of the MOU. It is a case of the plaintiff that the defendant had failed to execute the MOU within the period of 3 months. As such, a notice was issued on 8/2/2022, calling upon the defendant to execute the joint development agreement. The defendant has given a vague and evasive reply by notice dated 25/2/2022. As such, it made the plaintiff to file the incident suit. In the suit, the defendant had filed the IA number 4 under Order 7 Rule 11. It is Order 7 Rule 11, IA number 5 under Order 7 Rule 11. It is stated that there is no concluded agreement or contract of a binding nature has ever been entered into between the parties to the suit, and hence, in the absence of any concluded contract between the respective parties, the suit is grossly misconceived. And it is also the case that there is no kind of consensus ad adam between the parties, and the professed memorandum of understanding is void ab initio, and it has not conferred any kind of right on the defendant, on the plaintiff. And further, it is stated that plaintiff has sought to proceed on a fundamentally erroneous and subjective assumption that the memorandum of understanding has created in its favor legally enforceable right. Further, the professed readiness and willingness to perform its part of the contract under the memorandum of understanding is at a misnomer, and a misconceived notion on the part of the plaintiff, as there is no contract entered into between the parties. As such, it is also stated that the plaintiff do not conform to the provisions of Order 6, Rule 3 of the CPC and does not even conform to the essential requirements of either Form 47 or 48 to Appendix A of the CPC. And according to the defendant, the plaintiff had no cause of action in the suit as stated is liable to be rejected as per Rule 11D, Order 7, Rule 11D. The trial court, by order in June, rejected the said application. While rejecting the said application, the which page?
Para 16.
So this is dated 18/3/2024. Yes. Order dated. The court, while dismissing the application, has observed that as per the settled law, while considering an application for rejection of claim, only the plain evidence must be looked into and not the written statement or the evidence in the application for rejection of claim. And according to the defendant, the Memorandum of Understanding dated 12/3/2021 is not enforceable as it is not a valid document. The court observes that the nature of the document in question and whether it forms a valid contract is to be determined by appreciating the contents of the said document and upon a wholesome reading of the document. The same cannot be done at this stage when the document is not yet tendered in evidence. The validity of the Memorandum of Agreement dated 12/3/2021 and its enforceability is a matter of trial and cannot be ascertained at this stage. Further, the aspect of consultation and the passage of consultation between the parties is subject to proof and can only be determined by considering the prevailing facts and circumstances, and the same cannot be considered only looking at the agreement and accordingly dismiss the application. In the said order, the court had the order also discloses that the plaintiff had relied on as many as 8 judgments and the defendants have relied on as many as 7 judgments. Next paragraph. The senior counsel appearing for the defendant petitioner submits that there is no privity of contract between the parties and the contract is not a concluded contract. And the relief as sought for by the parties, by the plaintiff, is not maintainable. He has relied on the judgment of the Apex Court in Speech and Software Technologies India Private Limited versus Nuance Interactive Limited, reported in 2009, 1 SCC 475. Particularly, he relied on para number 22, wherein the Honorable Apex Court has held that It's a well settled legal position that an agreement to enter into an agreement is not enforceable, nor does it confer any right upon the parties. The agreement in terms of the said letter of intent was to be signed, that's it, upon the parties. Relying on this judgment, the senior counsel submits that such a relief as sought by the plaintiff is not maintainable, and the court ought to have considered the same and ought to have allowed the application filed under Order 7 Rule 11. He submits that when they have relied on several judgments and the judgment of the Honorable Apex Court particularly with regard to seeking the specific performance in respect of a contract which is not yet concluded, the court had failed to consider the judgment. He submitted that the order that is passed by the court is bereft of reasons, and the same is liable to be set aside. He submits that court in a mechanical manner has simply held that at this stage all the issues cannot be gone into. It is submitted that they are only relying on a document that is filed by the plaintiff along with the plaintiff. There's a memorandum of understanding. Basing on that, they have demonstrated before the court that the suit is not maintainable, and it has to be rejected. The court ought to have considered the same, and also the judgments relied on by them. Next part. Senior counsel, appearing on behalf of the respondent, submits that this particular contention was never raised. According to him, it is submitted that the one contention is with regard to the consideration. The senior counsel submitted that it's purely a question of fact, and that that cannot be decided at this stage of where an application under Order 7 Rule 11 is filed. He further submits that this particular ground with regard to that the contract is not concluded was never taken by them before the trial court, and now it is not open for them to raise such a ground in the revision. In response to that, then senior counsel submits that clause number 4, the ground number 4 that is raised in the paragraph number 4 of the application clearly discloses that such ground was taken by them. It is submitted by the senior counsel appearing to the respondents that court had considered all these aspects and rightly dismissed the application as all the contentions that are raised by the defendant are beyond the scope of an application under Order 7 Rule 11. 7, and there are no grounds to interfere with the well-considered order passed by the court. Next one. Having heard the senior counsels on either side, there is the material on record. The present suit is filed seeking the relief of seeking a direction to the defendants to execute a joint development agreement. It is the case of the plaintiff that an MOU is entered between them on 12/3/2021. As per the same, within 3 months, a joint development agreement has to be executed. And in spite of issuing a notice, as the defendant has failed to execute, they came up with the present suit. It is a contention of the defendants that there is no concluded agreement between the parties. Then once there is no concluded agreement, they cannot seek enforcement of such agreement. In support of their contention, they have relied on certain judgments, and this filed this application seeking rejection of the claim. The senior counsel appearing with the respondent submits that there are judgments to the effect that even for a enforcement of a memorandum of understanding, a suit can be maintained, and they have also relied on several judgments. This court had, in the light of the respective stands taken by the parties, this court had perused the order passed, the order impugned in that, though the court cites about the judgments that are relied on, but what is the application of those judgments to the facts of the case was not at all discussed by the court. As rightly pointed out by the senior counsel for the petitioner, it appears that the court in a mechanical manner had dismissed the application. The court ought to have given a proper reasons how on the maintainability on the application under Order 7 to 11 in the light of their contention that it is not a concluded contract and it's not an enforceable. As such, the plaint needs to be rejected. Considering a perusal of the impugned order shows that it is not a well considered one. In that view of the matter, this court deems it appropriate to set aside the order and remand the matter to the trial court. Accordingly, this court is passing the following order. 1. The order impugned so-and-so by so-and-so is set aside and the matter is remanded to the trial court for fresh consideration. The parties, both the parties, are at liberty to take to if both the parties wants to come up are at liberty to raise their effective grounds, and if necessary, both the parties are at liberty to raise additional grounds, and the application shall be decided by the court within a period of 3 months from the date of receipt of the copy of law.
Good. Great for the court.
Yes.
So this is Banta. Petition is filed in the challenging central mistake number. This is filed under section 157.
Where is the respondent? You have an interim order?
You have an interim order that I have.
No representation for the respondent. This is
Last 4 occasions.
24 matter. The no representation for the respondent's interim order earlier granted is extended until further orders. This is matter after winter vacation. Yes, next. I think 39 is adjourned.
39.
Then council submits that as per the order, they have been continuously depositing the amount, and also the arrears, although the interim order passed by this court is complied with in toto, and they are continuing to deposit the amount. Interim order earlier granted is extended till the next date of hearing. This is matter to give a date around Jan 20th or something. No representation for the respondent. Yes, next. Yes. Any interim order?
Your Lordship, interim order earlier granted by this honorable court. The subject to deposit of
they are not
deposit.
They are deposit.
Your Lordship had given permission to withdraw the amount.
Already given or you want?
No, you are given.
The no representation for the petitioner. Consider the respondent is present. This is matter after winter vacation. Give some dates. Not all the cases in one day. Two cases and one. Consider the petitioner is present. It is submitted that they are complying with the interim order. Complying with the interim order earlier granted is extended post after winter vacation. What is that? No, will not hear. Yes.
Silver 41. Silver 41.
Some has come in challenge. saying that he's not ready to pay maintenance amount to the father now.
Any interim order? Monthly maintenance or arrears as per order date received. No representation for dismissal tomorrow. Yes, next. Okay. You have an interim order? You are not filed IA. Don't want it. Then you are for the. Then where is the question of IA? How much is no, your case is dismissed?
Yes, this is on the ground that she herself left the.
Let's see that. Let's see that finding.
Please. Page 26, your paragraph 22.
Read.
There are documents you have to show that you are designing the sufficient income. The user certificate that you are designing the lands. The right of Malloy. Another point is the application by the husband. They say that she is having a relationship with her brother, cousin brother. That is not good. They might have application.
What is this?
Please, my lord. Page 24, internal para 19. Your lordship may kindly para 19 of the judgment, my lord. She is having a illicit relationship with another person, one name called Manju, my lord.
She is having a relationship with her brother, cousin brother. That is not, in that aspect, we are not using document
And also, para 21, your lordship. Para 21, my lord.
No, who has to discharge the burden? No, whether she is living in adultery or not, everything will be proved under 125.
Already she has admitted in para 19, my lord. Your lordship may kindly tell para 19, my lord. It is crystal clear.
Yes, no, this is smarter. This is smarter for final hearing. Here. Admit for final hearing. Post smarter for final hearing. Yes.
Girish, can you already?
The matter is out of court settlement. I am telling you the 125 proceedings here. The husband and wife filed before the principal
The matter is settled.
They are going to be settled as per the
This
party
matter
instruction.
of winter vacation. It is submitted that there is a likelihood of settlement. Next.
Please.
And general.
Don't give so many days. Just keep on going back, 9, 10, 11, like that. Yes.
Number 44. Nagaraj Appano.
filed a translated copy of the same. But the matter arises out of my application which was filed by the present defendant.
Also suit for?
It's suit for the declaration and partition. The suit is filed by plaintiffs claiming that they have tenancy rights in the suit property. Wherein they claim that they have to be declared as permanent tenants with respect to other tenants. 168 they have sought with each other, all 6 tenants.
Who will declare them as permanent tenants will court. Hmm.
But the original owners are not made as the parties to this. And earlier the lessees and their who they have got rights from, they are not parties to this. But in between the last lessees, they claim that they are in the possession.
Let's see where is that translated copy you have found.
Along with the memo. So start from page number 18.
Let's read.
Brief facts of paragraph. Originally, the suit scheduled property belongs to one Venkatesh Chidambar Dattatraya sons of Gopal Kulkarni. Out of them, Shri Dattatraya son of Gopal Kulkarni as a manager of HUL leased the suit scheduled property on 13/9/1913 in favor of the joint lessees by name Himokka to Lakshman of Gandhi for the lease amount of ₹60 per year. And the said lease period was for 50 years from the date of taking permission from collector. Thus, the said lessees got constructed the ginning factory and got installed the machinery and started to run the same. And after 4 years, due to some inconveniences, they have sold the leasehold rights of the said ginning factory along with the machineries to one Navroj Belgaumwala, and he was running the said ginning factory for 9 years. And thereafter, he has sold his leasehold rights in favor of Irjamai Belgaumwala. Thereafter, the said Irjamai also could not run the said factory, also could run the factory for 7 years. And thereafter, she also sold the leasehold rights in respect of lease property along with the machineries in favor of one Siddhappa, two Kotrappa, three Ishwarappa, four Prayantappa, five Hanumatappa, and six Krishnappa, seven Somshekarappa of Gandhi on 14/12/1933. Thereafter, they also could run the said mill for about 21 years, and thereafter they have sold the leasehold rights of lease property in favor of the propositors of plaintiffs number 1 to 10 by name Rudrappa, number 2 Ishwarappa, 3 Baswanagoda, 4 Basappa, 5 Nagappa, and 6 Basappa on 20th/9/1964. Thus, by keeping the suit scheduled property in their joint possession and enjoyment of the said 6%, the son of one of the said joint holders of Nagappa, Siddhappa, Nasrul of Epadi, by name Somshekarappa, has sold 1/6 share of leasehold rights on 6/1/1986 in favor of Somshekarappa, son of Putrappa Sultan. Thus, the defendant number 1 to 15 have got 1/6 share in the leasehold rights of the suit scheduled property. Likewise, the plaintiffs number 1 to 10 have also got 1/6 share in the leasehold rights of the suit scheduled property, and the defendant number 20 to 56 have got 1/6 share of leasehold rights of suit scheduled property, and defendant number 57 to 62 have also got 1/6 share in leasehold rights.
Where is that IA?
My IA is page number 61. Sorry, it's at page number 62. 62.
62.
Application, the affidavit of the reasoning starts at page 64.
According to you, why it should be rejected?
What has happened? Now they are claiming that the lease was for the earlier. They themselves in the claim clearly admit that the earlier lease is for the 50 years. Lease is of the year 1930. They came into procedure, they say that they are 1954. Thereafter, they claim that they have continued in the property, and what they are claiming is, the worship may kindly see that they want to get declared themselves as permanent tenants. But that cannot be, they cannot be
Can the civil court grant such declaration?
Not permanent tenant. He is having 1/6 leasehold right only.
Given by whom?
Given by whom? Originally Javli family.
No, you are referring to the Land Reforms Tribunal, the orders that are passed. After the lease given to you by the lessee, thereafter before the Land Reforms Tribunal, certain things have taken place. Then how can you rely on that? And as per that, mutation and everything is done in the revenue records. Then how can you question it?
Because
Without
also-
even questioning that, that entries that are made. As per the, it is
Here,
as per the.
here also, I question the entry made in favor of the
No,
defendant.
come to the relief that you sought.
Lots of cause of action.
Not cause of action, the relief that you sought.
Please vote. To declare that the plaintiff have 1/6 share of the perpetual leasehold
How
right.
can the civil court declare that? Can the civil court declare that?
Lordship, because lordship,
In the light of the proceedings by the Land Reforms Tribunal or the proceedings that are before there, it has, who are the owners of the property, who are they, everything has been settled and you didn't participate.
not settled. There is a dispute in between the all of the common.
Then who will
tenants.
decide? Who will decide? What is is there no bar to go before the civil court in respect of the disputes pertaining to land reforms tribunal?
That is not, this matter is not pertaining to land reforms matter.
No. How can you, how are you entitled for a permanent tenancy? Under which law? Is there any law? If anybody is entitled for a tenancy right, under which law he is? If somebody has to be declared as a tenant and you are having any occupancy right or anything, under which law it will be done? Something if you say that
because of cause of application, this is application filed for the second time also. Earlier lordship depend number 4 depend number 72 collided with each other lordship.
That we'll forget. That we'll forget about. You say 1913, there was a lease for a period of 30 years. Thereafter, before the Land Reforms Tribunal, the proceedings have taken place. The rights in respect of that particular property are concluded by the Land Reforms Tribunal. Now you are questioning something which has attained finality before a civil court. Is it not?
In this last.
What happened was one of the claimants claimed that it is agricultural property.
Then the tribunal said by that time it has already been converted as a non-agricultural land.
But thereafter, the claimant's name has been entered in the tribunal records. He has continued for 30 years.
In pursuance of the proceedings of the Land Reforms Tribunal.
That is not true lordship. Lordship, original lordship, there are 6 families in the.
No. We will take from your own plaintiff, nothing else. What are from your very contentions in the averments in the plaintiff, we will look at it. Please come to the plaintiff.
Please.
You only referred to the proceedings of the Land Reforms Tribunal.
After dismissal of lordship,
para number 5, please.
The Land Reforms Act was introduced in 1974, and due to this, in the record of rights, the name of the government was incorrectly mentioned as the owner of the disputed property.
So, you are accepting that the proceedings under the Land Reforms Act are concluded. You, according to him, according to you, it is misrepresentation or misunderstanding, whatever it is, the proceedings are concluded. Basing on the order that is passed by the Land Reforms Tribunal, other limitations have been done. How do you put the clock back?
Lordship, for a moment, lordship, paragraph number 9.
No, 5 read. 5 you complete.
Please. As a result, one of the claimants, Somsekhar, son of Kotrappa Sodhi, filed an application under misunderstanding with the land tribunal. The land tribunal later ruled that the disputed property was not agricultural land and dismissed the application. Later, the Sodhis approached the deputy commissioner, deputy sub-divisional officer, Haveri, seeking to remove the government name from the record, and the deputy sub-divisional officer, Haveri, has ordered to delete the government name from revenue records. Despite knowing the fact that dependent number 1 to 15 only have their 1/6 share share of perpetual leasehold rights in the scheduled property. The dependent number 1 to 15 misused the government order and fraudulently recorded their names as exclusive owners in the rights trust. The original owners of the suit scheduled property, the Jowli family has filed an original suit number 91/2006 against the plaintiff number 1 to 10, the defendant number 1 to 15 and 20 to 78 before the Honorable Supreme Court badly. The said Honorable Court dismissed the suit on 26/11/2012, stating that it has no jurisdiction over the matter. Later, the Jowli family had filed a miscellaneous application number 1/13 before the Honorable Court. The heirs of the original owners Jowli and defendant number 1 to 15, with mutual agreement to defeat the rights of the other, have filed a memo on 6/1/2016 and got dismissed the case. Despite being aware of the fact that the plaintiff have 1/6 share share of perpetual land lease rights in the scheduled property. Similarly, dependent number 20 to 56 have a 1/6 share of perpetual land.
No, I'm not able to understand how this prayer that you're seeking is can be granted by the court to declare that the plaintiffs have 1/6 share of perpetual
Because also in the miscellaneous appeal lawsuit filed by the original owner of the land lawsuit, by suppressing the fact lawsuit, excluding my rights lawsuit, other tenants are filed.
No, tell me under which law you will have the perpetual leasehold right, under which law?
I will get proper.
This is not the next week. And they shall give, that calls for the petition submits that the application that is filed at order 7 to 11 is dismissed by the court without appreciating the facts. It is submitted that the petitioner plaintiff is the respondent plaintiff is seeking the relief that he should be declared as a perpetual tenant in respect of 1/6 share of the property. He submits that such a suit is not maintainable. Considering the submission, they shall be stay of all further proceedings. Invoice number so and so till the next date of hearing. This is matter after some winter vacation. Yes, next.
Dispensation of notice to others.
Next docket order. INM, the memo is filed seeking dispensation of notice to respondent number 11 to 18. The memo is taken on record. Notice is dispensed with at the risk of the petitioner. You appear for?
Respond number
2 to 7 they have filed.
Mr. So-and-so has filed vakalat to respondents 2 to 7. Registry is directed to issue notice to 1, respondent number 1 and 8 to 10. Right. Next.
May I request for 17 minutes from personal our books.
Post after vacation.
May I request 17 minutes.
After vacation. Yes. Next 46.
Last occasion, last directed file a statement of.
Which day after vacation? 46 after vacation.
The lordship directed me to produce the bank check. I have produced it.
Let's say it's a
Arrears also there, Malad. They are not paying in regular.
Interim is there.
Interim order is there. And 5,000 orders there.
Okay.
I completed the interim order, and every month I have, as per the direction of this honorable court, my lord, 75 rupees has been deposited, and also my learned friend has withdrawn it, and every month
What is 75 rupees?
75,000, my lord. That is deposited, that has been withdrawn, and every month.
Monthly you're paying?
Monthly 5,000, my lord, as per direction of this honorable court.
That council submits that as per
My
the order.
my request is, my lord, from August we have not paid. Up to 5,000, my God, the order sheet.
Two more, and council for the respondent submits that as per the order passed by this court. From August, no amounts are paid. Then council for the petition shall get instructions or is the order passed by this court will be vacated, list this matter tomorrow. Not tomorrow, list it on Monday. Yes. Only to that aspect. Yes, next.
Number 48. Sibuti, Vijayanagar. 48.
Yes. Yes.
Pursuant to the Lordship's direction, my Lord, we have removed and the photographs have been
Yes,
received.
Mr. Counsel, what is
Yes, madam, they have not complained, madam. They have, no, I'll show the photographs, madam. In the road, they have dumped cattle manure to the extent of 4 feet to 13 feet. They want to give the road as charity, not the decree road. I want the road as per decree. Yes, as per decree.
As per the decree itself, my Lord, we have cleared.
Here it is the photograph.
This is photograph taken on 9, that is yesterday Monday.
Yes,
Monday.
this is the photograph of my client.
both the photographs?
Yes. This is the latest photograph.
Appears to be not the same. This is what you are giving.
Yes.
This is what he is giving.
No, yes, I'll see that photographs.
Give it to him.
Yes.
As per the court decree.
I think your client is unnecessarily taking a chance.
Yes, ma'am.
But discuss your revision.
Yes, ma'am. This is yesterday photographs, my
Yeah,
client.
this, the present revision is fine. Agreed with orders passed in. Where is that order?
My Lord, order is that
Agreed with orders passed in EX 10 of 23, dated 29/6/2024, whereby the court had passed an order directing the JDRs to go for the civil imprisonment, to undergo civil imprisonment for 3 months for willful disobedience of the orders of injunction passed by the court. Then counsel appearing for the petitioner submits that there is no intention on the part of the judgment debtor to disobey the orders of the court, and the court, without considering any of the aspects, had allowed the petition in the judgment debtors or in the civil prison. This court, then counsel, this court on this matter came up on the last occasion, has given an opportunity to the petitioners to, has indicated to the land counsel, the petitioner, that if the encroachment is cleared, as per the decree, if the pathway is cleared, the court would pass appropriate orders. This matter underwent several adjournments at the request of the land counsel for the petitioner. Today, both the parties have placed the photographs before the court. According to the petitioner, they have cleared, and according to the respondent, they have not cleared they have not removed the encroachment as per the judgment and decree. Having heard the arguments of land counsel, the petitioner and the respondent, on the face of it, it appears that there is a willful disobedience of the judgment and decree passed by the court. And in spite of giving an opportunity, the respondent, the petitioner, has failed to comply with the order, comply with the judgment, and in that view of the matter, this court finds no reasons to interfere. Accordingly, dismissed.
Number 49. Yeah, 49.
Is not well enough.
What is this? What is the transfer is seeking?
Deceased. And respondent number 2 and 3 are the parents of the deceased son. All the petitioner and the respondent number 2 and 3 have jointly filed an amnesty petition seeking compensation. That too, the petition is under section 160. And the respondent number 1 insurance company has agreed to settle the case for rupees 15 lakh. The company has also issued a joint memo to the debtor.
and the respondent number 2 and 3 have also signed the joint memo. When it was presented to the before the court, my lords, at that time, the respondent number 1, the petitioner here, wife, declined to sign the memo.
On the ground?
Some instigation of some area.
And now what is where to, she's seeking transfer from where to where?
Lords, that seeking transfer from Gadar to Dharwad.
Lord, there are two petitions, my lord. I am for the insurance company. We have issued the joint memo, whatever they are entitled for the 15 lakhs, we have issued the joint memo. They have not presented before the court.
So what is the difficult thing?
They want to transfer the petition from Gadar to Dharwad.
Lords, I am crossing, Lords, this may be taken up on Monday, Lords.
Suppose it's not on Monday, we'll see.
Let's see, only if the petitioner.
No, under 163A, there can't be any other dispute on that. What is entitlement?
My lord, there is a dispute between both parents
No,
and the
not
wife
about-
is that
So-
only apportionment rate. Nothing more than that.
Who represents the respondent? That, the mother-in-law and all?
No, my lord, he is
You are
for the,
representing.
I represent them.
he is for the parents, my lord. The
So
other
as per the joint agreement, how much is to be disbursed?
15 lakhs.
Only the amount is arrived. Only in respect of the apportionment, the court has to pass an order.
My lord,
This is the only stage which has been done.
No, what is the case of your client? No, they are the wife. Children are
in
there.
respect of the apportionment, there is
No,
no
children
demand.
are there.
No.
Children are there. Children of the
Children,
deceased.
wife and daughter, my lord.
And here are parents.
Father and mother.
And the parents, like, is the only son or other sons are also there? Get instructions, why should unnecessarily be?
Mother.
And you can't have a half of the amount.
Regarding the apportionment, we are not having any dispute.
Probably that's an apprehension in
Off
that
the
fact.
records, their dispute is that, some other benefits have been taken by the in-laws. That cannot be decided in this petition.
And let's see, you let the council come.
My submission,
Monday.
I am the insurer, my lord. My submission is that, my lord, it was referred to Lok Adalat. In Lok Adalat, there is an order to deposit the amount before this court. But without there is any order of the trial court, I am not in a position to deposit.
How can the amount be deposited?
Right. My lord, it has been passed in the Lok Adalat, my lord, on 14/7.
You have that order?
Yes, it is noted in the option.
Let's see.
My lord, I am not in a position to, it's a technical error in the company to deposit the amount.
Because NBC itself not been calculated, there is no order to that effect, My parties were not present on before the local Adalat because of medical reasons, They are insured parents, they are unable to travel.
The only no order, it is advisable. It is advised. No order is passed. So that is not binding on you. How can all this be decided in a CP?
My lord, only.
Unless and until
My
there is a
lord, on
consent of the
Monday, my
party.
lord, it gets concluded.
Yes, we'll see.
With the better, my
This is
lord.
matter on Monday. Tell him that what is transpired in the court.
My lord, for the further submission, my lord, it may reach us.
It will reach Monday.
Please.
Number 50, they should be Authorized. Turnover.
Seeking for a transfer of matrimonial case from Shikam to Dharwad family court.
How much is the distance?
Distance is more than 50 kilometers and about.
Which year is the MC?
MC is in 2023, madam.
What is the stage now?
Stage is for hearing of interim application, which I filed application on 24 of CPC, madam.
Just file the wakalat and the objection. The main petition hearing is pending before the trial.
So evidence has not come in?
No, not.
Then we'll transfer.
No, what happened? Earlier, the respondent decided he is allowed only. He has a life threat. He is the brother of the.
File your objections then.
Yeah, please.
The petition,
Please.
the request of the council respondent in this matter after winter vacation
2 weeks.
for filing these objections. Interim order is there.
This notice.
Huh?
Interim order is there, my lord.
Interim order granted is extended to the next date of hearing. Yes, next.
Please.
Still number 51. Santosh Pirao.
Interim order passed by this honorable court has not been complied.
Not complied with. List this matter on Wednesday. Yes, next. Yes, next.
Still number 52. Still number 52. Partition syllabus.
Arrears of monthly maintenance have been deposited
Can be taken on Monday, my lord, sir. What is the document?
Tuesday.
In this matter, wife is ready to join, my lord, and serial number 59 is
Yes,
a
ma'am.
transfer petition filed by the wife, my lord.
4th, 52 and 59 post on Monday.
Please, I'll present the package.
Yes. Next. Yes, next.
Still number 54.
My lord,
He's
he's in army, my lord.
He's in army.
He's on,
Not parties, both are connected, get instructions.
Please.
Yes, 54.
54. Jagdish Patil.
Because the petitioner,
My lord, I'll take notice for the respondent. I'll file the
How much is granted?
30,000 accounts.
30,000. You are for the
I'm the husband.
30,000. And how much is the salary of the husband?
And take home
I
is
mean, your salary.
it's around 2 lakhs per month. Take home is 1,30,000.
1 lakh?
30,000 accounts.
Then what's the difficulty?
The order might find is in case 57.
Hmm.
On the day of the order was passed, the matter was posed for compliance. Even before my me reading the evidence of proposing my defense, the trial court is looking into the writ petition which was referred by the petitioner for the challenging the order for interim maintenance. The reasons given in
No,
that
no.
petition, this order has been
Whatever
passed.
it is, that reasons is here. For paying 30,000, you have no difficulty when you're earning 1,30,000.
Still, the
The-
quantum, even the wife is the
So
earning.
and so submits that they have instructions to appear on behalf of the respondents.
Meanwhile, I asked for the interim.
This is matter after winter vacation. Yes, next.
Still number 55.
Yes, 55.
Wife petition
Ah.
to be dismissed in this trial court.
Notice.
My lord, not for a stay, not to withdraw the amount which is deposited before court below. The husband has deposited 50,000, 50%. May I take, my lord, in page number 13, my lord,
This is filed by the wife seeking enhancement.
not enhancement,
Ah.
challenging the order passed by the trial court, my lord. Well, trial court has dismissed the maintenance petition.
Correct. This is by the wife.
Please, my lord.
But then what is the interim order?
There is a notice of trial. Husband has deposited 1,40,000, my lord, as per direction of the court. Now he is withdrawing that amount, my lord. That's why I'm saying.
The wife is aggrieved with the order passed by the family court, agreed with the dismissal of the application seeking maintenance. It is submitted that during the pendency of the said petition, amounts were deposited by the husband, and now he is going to withdraw the same, considering the submission. There shall be a direction to the respondent not to withdraw the amount. Yes, notice.
Obliging.
Yes.
Number 657.
This is the one you are referring to. It's different, yes.
the wife petition being transferred from Lakshmeshwar to Dharwad.
Use the mic.
Wife petition, my lord, seeking transfer from Lakshmeshwar to Dharwad.
Distance.
108 kilometers.
Which year is the MC?
2023.
What is the state now?
For filing of objection.
Sure.
Please.
The present petition is seeking transfer of MC number so and so from so and so to so and so. It is submitted that the distance is 108 kilometers. Considering the submission of the land counsel the petitioner, there shall be stay of all further proceedings.
Already stayed there, my lord.
Then why has it come?
After service, again this.
The is filed. Then you filed the proceeding sheet. Proceeding sheet.
Oh, produced.
Where is that?
Order sheet is at page number 19.
19. What you see here,
I'm seeking transfer from Lakshmeshwar to Ravana.
notice to respondent served 3010 of which one? 3010-2024. The present petition is filed, seeking transfer of MC number 54 of 2024, pending on the file of the senior civil judge and JFFC Lakshmeshwar to the family court at Davangere. The facts of the case are the marriage was organized on 21/5/2017. And it's a case of the wife that, because of the ill treatment, and it is her case that she was ill treated and she was forcibly thrown out of the matrimonial home on 28/4/2018. And she left to her parental house. Thereafter, she filed an application section 21 of the Domestic Violence Act in criminal miscellaneous number 170 of 2019, pending before the first additional senior judge and JMFC court, seeking maintenance. And thereafter, the present MC is filed with the husband, seeking restitution of conjugal. MC is of 24, not 23. Has filed the MC, seeking restitution of conjugal rights. It is stated that the distance between both the places?
108 kilometers.
Huh?
108 kilometers.
108 kilometers. particularly the one which he is relying.
Yes.
This is in case of P.V. Gururaj Reddy and P. Nirada Reddy and others.
Yes, I have.
Reported in 2015 8 SCC 331. Now here, in the cause of action, give it to him. In the cause of action, they have said so that their knowledge is from the year 2019. So what the Supreme Court said is, as far as the law of limitation is concerned, at the point and when dealing with an application order 7 to 11, we have to confine to that their knowledge about a particular fact.
Now, this appears to be a judgment much higher than the ones which are.
Let's see that. Which are the judgments you relying on? Yes, you have given a couple of judgments, yes.
Yes.
Yes. Which one you are relying on?
All of them, and I will take chronologically.
Yes. First one is Supreme Court judgment, 2019.
Now, this was dealing with cancellation of a gift deed registered somewhere in the year 81. And suit comes to be filed after the passage of 10 years. And the Supreme Court ordered the opinion that it is barred by limitation.
Let's look at the that observation of the court, Supreme Court. Para number 7.
Yes. Applying the law laid down by this court in the aforesaid decisions on exercise of powers under authorized to the facts of the case in hand, and the opponents in the claim, we are of the opinion that both the courts will have materially earned in non.
Sure, the issue is about the knowledge of the plaintiff, about the execution of the
That is, in this case, Article 58 is the one which governs suits for declaration. Now, that is the reason why the Honorable Court as well as the Supreme Court were of the opinion that date of the knowledge is not material. What becomes material is
Section 3 of the Transfer of Property Act.
3 of Transfer of Property Act has not been expressly considered, but nevertheless, the limitation prescribed is to obtain any other, the Federal Crime Protection, Article 58 of the Litigation Act. To obtain any other declaration 3 years, when the right to sue first accrues. So, Section 3 of the Limitation of Transfer of Property Act makes it, mandatory that it's a constructive notice, registration is a constructive notice, and by all due diligence and prudent man is supposed to have known the said fact of registration. So it begins in the year 1991, as far as this plaintiff is concerned. That is the reason why so many judgments, they deal with when the right to sue accrues. When the right to sue accrues, the moment registration happens. Right to knowledge, the date of knowledge.
Where that particular aspect is dealt with, like their knowledge is not the relevant factor.
No. What the courts have done is they have taken the date of registration into account and held that this is part of limitation.
No, you should please read this 7. I think there is it can be distinguished on facts. 7. 7, para number 7. I think it's on facts, it can be distinguished.
Even other judgments.
Other we will see. The other judgments you please point out. Next is 2022 Supreme Court.
Now, I quote from the judgment. The deed of gift was registered gift deed. The execution of the gift deed is not disputed by the plaintiff. It is the case of the plaintiff that the gift deed was a showing deed of gift, and therefore the same is not binding on him. However, it is required to be noted that for approximately 22 years.
Because precisely in this case, they have a knowledge about the gift deed, but they just say that it's a showing gift deed. That's it. So the court held that there is the knowledge is there. So on that aspect, this judgment is given.
Perhaps I may be too moment, but then there are the judgments which also say
where the plaintiff feign ignorance and they claim, we came to know just about yesterday that such a thing has happened, so my court of action starts.
So that's where it comes, it's a question of fact and law, because now he's pleading that I came to know yesterday. Now, in the course of the trial, the court will decide if such a plea can be taken or not, and whether such a that is a genuine plea. Then section 3 of the Transfer of Property Act, all of that will come to play at that point of time, looking at whatever the questions of fact that they are raised with them.
Now, as far as my submission goes,
So the same judgment come to 8, para number 8 of the same judgment.
now, so far as the application on behalf of the original plaintiff and even the observations made by the learned trial court as well as the high court, that the question with respect to the limitation is a mixed question of law and fact, which can be decided only after the parties read the evidence is concerned, as observed and held by this court in cases of Shamraj Elias Kuldeep, Henry Srinivas Murthy, as well as in the case of Ram Prakash. Considering the arguments in the claim, if it is found that the suit is clearly barred by law.
So, if it is an open and shut case like this, you are aware, you yourself agree that they are aware of the guilty dated so and so, and files a suit after 22 years. So, main on the face of it, there is no fact involved in that. It's a clear case. So, the court held that it can be done. Then let's go to the next judgment. AR 2022 Supreme Court.
22. This is very much later than the one which is relied by.
That we will see. Which para?
Yes. And come to there are 7.7.
7.7. There's some confusion with this pagination and all. Something like there's a reverse, it is filled.
Sorry.
7.7.
Oh, this, the page is printed reverse. I'm sorry, can I present to the
No, let's see, unnecessarily by again with joining it. 7.7 is here, yes.
Yes. Even the averments and allegations with respect to knowledge of the plaintiffs, covered in paragraph 19, can be said to be two-way. Nothing has been mentioned on which date and how the plaintiffs had the knowledge that the document was obtained by fraud and or misrepresentation. It is averred that the alleged fraudulent sale came to the knowledge of the plaintiffs only when the plaintiffs visited the suit property. Nothing has been mentioned when the plaintiffs visited the suit property. It is not understandable how on visiting the suit property the plaintiffs could have known the contents of the sale and or the knowledge about the alleged fraudulent sale. Even the averments and allegations in the claim with respect to fraud are not supported by any further averments and allegations how the fraud has been committed or played. Mere stating in the claim that a fraud has been played is not enough, and the allegations of fraud must be specifically averred in the claim. Otherwise, merely by using the word fraud, the plaintiffs would try to get the suits within limitation, which otherwise may be barred by limitation. Therefore, even if the submission on behalf of the respondents original plaintiffs that only averments and allegations in the plaint are required to be considered at the time of deciding the application under Order 7 to 11, CPC is accepted. In that case also, by such vague allegations, with respect to the date of knowledge, the plaintiffs cannot be permitted to challenge documents after the date of 10 years. By such a clever drafting and using the word fraud, the plaintiffs have tried to bring the suits within the limitation, invoking Section 17 of Limitation Act. The plaintiffs cannot be permitted to bring the suits during the period of limitation by clever drafting, which otherwise is barred by limitation. At this stage, the recent decision of this court in the case of Tenancy is required to be referred. In the said decision, this court had occasion to consider all earlier decisions on exercise of powers under Order 7 to 11 CPC, which are considered by this court in paragraph number 6.4 to 6.9 as under. Now, with Lord's kind permission, I will quote within the court. In T. Aravindanandam, 1977, Part 4, Supreme Court cases 467, while considering the very same provision
and the decree of the trial court in considering such application, this court in para 5 has observed as under. We have not slightest hesitation in contending the petitioner for gross abuse of the process of the court repeatedly and unrepentantly resorted to. From the statement of the facts found in the judgment of the High Court, it is perfectly clear that the suit now pending before the First Success Court, Bangalore, is a flagrant misuse of the mercies of the law in receiving claims. The learned Munsi must remember that if on a meaningful, not formal, reading of the claim, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, he should exercise his power under Order 7 Good 11 cities, taking care to see that the ground mentioned therein is fulfilled. And if clever drafting has created an illusion of a cause of action, nip it in the bud at the first hearing by examining the parties searchingly under Order 10 CPC. An activist judge is the answer to irresponsible lawsuits. In Church of Christ Charitable Trust and Educational Charitable Society, reported in May 2012, Supreme Court 3912, this court in para 13 has observed and held as under. While scrutinizing the great governments, it is the bounden duty of the trial court to ascertain the materials for cause of action. The cause of action is a bundle of facts which, taken with the law applicable to them, gives the plaintiff the right to relief against the defendant. Every fact which is necessary for the plaintiff to prove to enable him to get a decree should be set out in clear terms. It is worthwhile to find out the meaning of the words cause of action. The cause of action must include some act done by the defendant. Since the absence of such an act, no cause of action can possibly occur. Then the court proceeds to examine the meaning of cause of action.
I have seen all the judgments which you are relying on.
Yes. And this honorable court, the division bench of this honorable court also considered in similar circumstances, suit for partition brought about, saying that we had no knowledge of the prior transactions and all. The court could not agree with the submissions of the plaintiffs, and therefore was of the opinion that it is barred by limitation. Now, if we look at the governments as a whole, 54 says his name disappeared. According to section 58, article 58, the right to sue appealed first in 1954. Then comes 1991 when the first sale happens, and followed by series of transactions. Mine is the last one.
No, in that case, then none of the documents that has to be 54 has to be applied. And in none of the cases you cannot question, because when the first cause of action arises in all the cases would be someday.
Yes, that is the reason, because a plaintiff can be said to be a plaintiff or a person can said to be had a right in a property. So if he has a right in the property, when the very first interference happens with that property or the right to property, that is the time when.
So in all the cases where you are seeking cancellation of the deeds and all, sale deed or any other deed, if this limitation and seeking a declaration that he is the owner, if this analogy has to be applied, then every suit has to be dismissed. The plaint has to be dismissed at the threshold.
Most of them
has to be.
That is without the intent of the law of limitation. When we think about the appeals and all, that is how the Supreme Court and the Honorable Court
even now in our Order 7 Rule 11 petition, we start reading Section 3 of the Transfer of Property Act. So it is about question of person notices. As per section, it's a constructive notice. It's a notice. Once it's a public document, question of which day does not arise.